All right, good morning, everybody. It is July 11th, and we'll call the meeting to order at 9:01. I appreciate everybody coming today, and unfortunately, we started the last meeting off thinking about everybody that's affected by the San Antonio floods, and our hearts are heavy today and are with all the I think almost everybody is affected some way or another, whether it's directly or indirectly by the floods in the Texas Hill Country. And I know several had very personal losses there. So our thoughts and prayers are with all of y'all and the first responders that are still out there. So we appreciate the work that's being done. This meeting is also a little bittersweet. We'll go around the room in a minute to do introduction. But this is every 2 years, unfortunately, we have members cycle off. We have two broker members and two lawyer members cycle off. And this time this is the last meeting for S.J. Swanson, for Lee York, for Amy Slusher, and for Ron Walker. And so we are going to miss them. I'll talk a little more about that later, but a special meeting for that. There's some of the ones that, at least when I became on the committee, that were the first to help me along. So we'll start with introductions. I'm John George, attorney member and co-chair.
Lee York, broker.
Brian Watts, attorney.
Melissa Haley, broker.
Ron Walker, broker.
Christy Tatum Jansen, broker.
Mary Minor, broker. Diane McCoy, broker.
Amy Slusher, lawyer.
S.J. Swanson, lawyer.
And I see online, we have, I see, who's there
Renee
first?
Harvey.
Okay.
Commissioner.
Commissioner Lowe? Okay.
Yes.
Commissioner Lowe. And then
Tony's on mute.
That's
that may be on purpose.
You made him smile.
Okay, and then if we go around the room, recognize our guest.
Tracy Shores, broker.
Kirsten Crawford, broker. Becca Cantu, agent.
Jennifer George.
Future real estate agent.
Good morning, Corey Connor, Texas Realtors attorney.
Chelsea Beckel, executive director for Trek.
And Abby Lee, track general counsel.
Okay. And then it looks like we have several guests online as well. Welcome. We're glad you're here today live. Today, our meeting is going to go over several things that we deferred from the last meeting. Last meeting was a fairly lengthy one. We made some good progress, and we'll pick up with several items there. And then we have a fairly short agenda of new items and a few comments to go over. So I think today would be more of a punctual meeting that we can march through. At first, I think because of the earliness of the shortness of the meeting, I like to reserve some time to let you know at the end. So if you wanted to say anything at the end to your swan song on the committee, you'll be welcome and have the opportunity to do that. I want to make sure you have that, because we definitely appreciate all the work that you all have put in. And it's been 12 years for Lee, Amy, and SJ, and it's been 18 years for Ron on the committee. So it's very special in all the work that they put in. So on that, we'll start with the the second item on the agenda, public comment on non-agenda items. And I did not see any on the remarks as I walked in. Do we have any public comments on non-agenda items? Okay. There being none, we'll move to the third item on the agenda, which is a report by the BLC working groups. And Ron, I don't know if you want to maybe start off with the water disclosures.
Yes. Well, we could defer to the forums because the group itself did not meet.
Okay.
Anymore.
And so we have, I don't believe there was any subcommittee meetings between our last meeting, which was just a month ago, and until now. We do have some of the changes that we made at the last meeting that were recommended by the subcommittees that we'll go back through. And so if we look at agenda item number 4 next, discussion and possible action regarding deferred comments and recommendations from committee members concerning possible changes to contract forms. And here we have a list of different things. One of the first ones I have is the legal holiday issue. And in our contracts right now, All the truck contracts have a definition, or not really a definition. It states that the earnest and option money deadlines can be extended if the deadline falls on a Friday, Saturday, or legal holiday. Legal holiday under the government code is defined as a list of specific dates. That includes a much more expansive list than virtually anybody understands it to be. And so our discussion last meeting was, do we now narrow the scope to what more agents, more consumers understand to be true legal holidays? And we kind of jokingly say, when is the title company open, right? That's a lot, one of the big ones. We talked about tying it to Federal Reserve holidays. And so what you see in the forms right now is the old thing we were considering about specifying where to go find the rule in the government code. The new language we need to discuss today is, I believe we were looking at Federal Reserve holidays. And in looking at the different ways that contracts use that term Federal Reserve holiday, there's one in particular I would suggest that we look at and use as a baseline. And I'll tee up first the concern about just saying a Federal Reserve holiday. It's a Federal Reserve holiday is not always observed on that day. It could be the following Monday or the Friday or somewhere around the date. And so with that in mind, I've liked having it, the language defined as a day, legal holiday, and then defined as a day on when the Federal Reserve banks are closed. Right? If you look at a quick Google search that I think most agents or brokers will do to find Federal Reserve holidays, the top of every list is the Federal Bank Reserve. And it takes you to a page that says, here's when the federal banks are closed. So I think practically that if anybody went to go search it, it would reduce controversy by having a consistent source. And also it removes the issue of the potential confusion if we just say a Federal Reserve holiday, it not being observed on that day. So with that, I'll tee that up for further discussion. If anybody had thoughts from last meeting or alternative suggestions, and maybe we can type that out so people.
Yeah, I will. I was going to share this.
I have two comments. First of all, there are different Federal Reserve banks, and so it would be the Federal Reserve Bank for Texas, which is headquartered out.
Do they each have their own independent holidays?
Each one can designate its own holidays. That'd be number one, and then number two, I think we may want to add the Friday after Thanksgiving, which the banks are not closed the Friday after Thanksgiving.
Let me add one other thing too, just to clarify. In the government code, it does refer to the federal holidays, which it actually calls the national holidays. And then it also, so the section we've referred to, which is the government code 662021, it says legal holidays include national holidays under 662003A, and then state holidays under section 662003.
Except for 3, yep. And then there's a few that are chopped off on that
But
list.
it does include, the state holidays include the Friday, by the way, Brian. So it's covered, but it's, as a lot of times in the law, you have to go to one law and then look at another one and another one. So this one, we have to look at two different sections.
If I just Google Texas
Don't Google.
holidays,
Don't-
I'm just saying, they're saying the state holidays and they're covering things that I wouldn't.
Well, Google's not what you need to do because there's,
Well, and I suggested that because we reduce controversy.
And I'm not
Well,
looking at law
but
and
it's,
they say closed on holidays. Where are we going? We're going to Google. I mean, I hate to say that, but we're going to Google.
well, I hate to
see-
say that too, because we're going to put it in the contract specifically, and you can Google what we put in there. You can Google Texas government code, but
Yeah, and that's where the problem with the government code, if we go there, like you pointed out, it includes like Confederate Heroes Day, San Jacinto Day, go down to, all these other ones that.
really should be.
Which one?
Yes.
Mhm.
Absolutely should be. It really should.
And
What'd
so
you
that's
say?
where we can look.
Texas
And maybe
Independence Day.
that's Brian's suggestion of the
Right.
Texas Federal Reserve might
Yeah.
get us there. Or
Here it is right
I
here.
wanted
This is
to
from
ask,
Dallas.
Okay.
I don't know, how they do it, but it at least seems like in our neck of the woods, the title companies are all closed on the same days. Like it doesn't seem to hop around like one title company's closed when another one's open. So what are they using?
Well, what I think people use is also the county holidays in the county where they are. The official county holidays because the courts are closed, usually the banks are closed. Then there's a lot of overlap. And so like Ron now has up on the board, this is the Reserve Bank of Dallas, that's great, but Brian, it doesn't have any of the days after Thanksgiving or the day after Christmas.
I like this, plus the day after Thanksgiving.
Well,
In the star,
Which means
if you
we're
go
gonna
down
be
a little
making
bit
it up.
more for the star, I think that's when it says
Well, that's exactly what this says.
in that bottom, the holiday policy, when a holiday falls on a Saturday,
but
Federal
I don't know
Reserve
what
Bank
you're looking
branches will
at.
be open the preceding Friday. Let's see. On its fall Sunday will be closed the following Monday. And so that language about when the Federal Bank Reserve is closed, that's where I think it becomes the practical side. All right. We have the legal definition and then that little star at the end. The title company can't transact business that day. They can't close a deal on that day, even though it's not a technical holiday. It's a day on which the Federal Reserve Bank is closed.
Mhm.
Well, they
And
can't
so-
fund.
Yeah, they can't fund.
I've closed on Sunday.
Yeah, that's true. That's true. Good point.
So are the banks closed on, I'm now looking at the federal part and it says inauguration day. Are they closed on inauguration day? I don't know.
I don't remember.
That's a Monday. That's all I was, bringing up. I don't know if they're.
It's not on this list, but it might be.
It's not in the government code. Here's my pitch for the government code. We are a government agency. And most of what we do, as much as we can, we follow the Texas statutes. That's been one of our guiding principles. So that, automatically makes me lean towards following the actual statutes that the legislature has decided are the holidays. But, okay, if we follow this and we wind up giving people extra holidays, all right, so they get March the 2nd, no matter what that day is, when they wouldn't normally, and they get April 21st, since in a day they wouldn't normally get. How bad is that?
What if taking your idea to expand that, just like, was it 021, I believe, has the reference back to national and state?
Yes, sir.
And so what if we took that and just said a national holiday or use the actual 662-003 A through blank in 662-003B 1 through blank, right? So then it specifies without doubt, without having to refer to 66021 and back. And I'm just talking this through, right, to see how it actually
that's
drafted.
good.
But that way it's specific and we could add in Brian's thought the day after.
After Christmas, yeah.
So we have that list, this list. Well, and again, if we include the state list, we are picking up the day after Thanksgiving.
Yeah, and what I'm saying is, use this language.
Right.
We can even say a legal holiday are the holidays under 662-003 A and 003B 1 through whatever ones we pick from that list.
Oh, I
without
see.
having to do a reference
I
to
see.
multiple statutes.
I see.
I think that,
But
and I understand your point on the government code and I agree with it, but I do think you said, well, if they get March 2nd and April 21st, well, that's great, but people are not going to know that. And then I feel like people will just there will be misunderstandings.
Yes.
If one party's going to know it was a holiday and then try to, I don't know.
Take
I
advantage.
think
Yeah.
that it's more consistent to be when the banks are closed plus the day after Thanksgiving. Because I think, and if it's the day after Christmas or whatever other, like you said, if you wanted to be selective about which ones you picked, but I don't think a blanket every state holiday is going to work. I just don't think it's practical.
What do you follow, Brian? And title?
Well, each title company is different.
Yeah.
My old job, if the banks were closed, we were closed. Currently, we have the certain set holidays, Christmas, Memorial Day, 4th of July. And then we vote on floating holidays. Sometimes we have Good Friday off. And this year we had Good Friday, but we didn't have MLK Day. So it depends on the company and your individual market.
What do the associations follow? Do you know?
Matter.
Is it school? I think they follow school. They follow.
think it
And-
Are you, you're talking about like local?
Yeah, I think they follow school.
I think every local is probably
I don't know that
different.
Yeah,
I don't, I mean, there's,
I mean, on.
They have nothing to do with
Not spring.
putting a
break.
contract titles.
I like where SJ's going. I like the idea of using and doing it the way you were talking about. This is the code that we're gonna use and all of A, because those are the national, and then B, and I think it was like 6, 7, and 8 or something. I had it pulled up a second ago.
I
Right
think,
there.
I agree.
Uh,
I'm
yeah,
with y'all. I
six,
think that
seven,
makes
and eight.
sense. I will say, whatever we decide, I think we also need to encourage Trek to publish
Yes.
a list and have it on the website at all times where somebody can just go look and see what they are. Because they're not gonna go look, many of them are not gonna look up this information.
Correct.
They're looking
it's
for,
for the
they're looking
reason
for a
is-
list.
Yeah, or a screenshot or
It,
whatever.
it needs to be easily accessible.
Mhm. For clarity. Yeah, because there would be a problem, like you said, there would be confusion in the marketplace if one agent said, oh, I know that LBJ Day is a day off and the other agent didn't, and somebody's
Uh-huh.
gonna say, we have the right to terminate because you didn't turn in your earnest money, and it
That's
would,
right.
there would be a lot of drama.
Yes.
So-
Yeah.
So
If
should
you
we
look in your
at that?
materials on page 2 of 92, there's draft language in there that already has some of the Texas government code language in there. And right now, we point to 021,
Which is A and B.
which is A and B.
Yeah.
So now we can just, under this thought, we could change that up to be 003.
662. Oh, no, 003, you're right, 003,
A.
A,
and
1 through
B, 6,
9,
7, and 8.
and 662, 003,
7.
and I think it's 6, 7, and 8. It's Friday after Thanksgiving, the 24th and the 26th of December.
In
Christmas
Texas
Eve.
Independence Day, did we, I know there was votes for
That
that.
was Lee.
Well, it's a Texas contract.
It is,
And I had that in the back of my head of, because of how even the government code sets up, Texas is even telling the national government what their holidays are, right?
Yeah.
That's, I love that here's what it is. So that's true, dear to my heart as well.
Yeah.
We're Texas.
yeah, and put in, let's put in an asterisk. Texas is the only state in the union that is allowed because it was a sovereign nation and we have the authority to do this, to make our own.
Don't you take your office out on Texas
I
Independence
do.
Day? I see the picture every year.
Center
but
Day,
Center
we
Day,
close, yes. We've done that for 25 years.
yeah.
66203 hasn't been changed in 26 years.
So that just gives it more
You get it right.
authority.
Well,
It's not.
if, and I like everything in A. When we pick B, 6, 7, and 8, that is going to create a situation where we would have to catch that if the law ever changes
Well,
to amend the contract.
that's what this
As
committee
opposed to
does.
just
You'll have to go on without
the
it.
Friday after Thanksgiving. Just specify,
Yeah.
it's the dates under 3A and the Friday after Thanksgiving, December 24 and December
So-
26.
If we do 3A, or A, everything under A, I think we talked about last time, that doesn't necessarily match up with the Federal Reserve holidays. And are we then circling right back around to, well, the banks are closed on days other than this that we can't
I
transact
mean, I would
business?
prefer to go with Dallas Fed.
Can we look at that again, Ronna? Did you have that handy?
I could figure out how to get back there.
I could look it up, but since you already did.
Oh, and yeah.
And we have Darlene, welcome to the meeting. We're in the middle of discussing our first real topic of business today on the legal holiday issue we deferred from last
There they
meeting.
are.
Right.
Yeah.
I've been listening.
Sure.
Well,
That one
but they
doesn't,
move around. So for example, like MLK Day is January 20th or the 19th or the 18th. And in the statute, it says the third Monday in January because that's what day it's going to be. Those
Right.
are the third Mondays in January.
Well, Memorial Day and Labor Day move around too. And so does the 4th of July, Independence Day. They
Yeah.
move around because they're,
It tells you all
Today.
that.
Yeah.
but they change in the calendar. I mean, that's why.
well, it's because it's a recognized, right.
Mhm.
Like, sorry, Independence Day.
Can you put it back on the bed one real quick?
You can do the fancy
Sorry,
split.
Ben.
Can you put the fancy split screen? So we can see that.
Mary, this year, Martin Luther King Day, which is a national holiday, was also Inauguration Day.
Okay,
But it will not be
for former years.
in other years because it's always January 20th.
Yeah.
So that's it. That was an interesting
Makes sense.
overlap.
So it's Columbus Day.
Columbus
Yeah,
Day
June.
moves around.
And Juneteenth is
Probably
not
we did again.
a national holiday.
In 4 years.
under the Texas statute. Because under the,
Wait a minute, I'm not
Doesn't say
seeing
that.
Columbus Day on the 662003A. So that's a difference
Isn't it
between
called something?
the two.
Isn't it called this thing?
Um,
Something?
October 13th.
Indigenous Peoples' Day.
Yeah,
That's another
Is it in
thing. I hate to say this, but going back to what Brian mentioned, the Texas has stayed the same, but the nationals that are listed in 662003 have stayed the same since 99, and they have changed. Some, just like you, Columbus
Bless you.
Day is now Indigenous Peoples' Day. They just changed the name of it.
Yeah.
But
And
I believe it is now a holiday.
Seeing that under 662 or 6.
Right.
What are you looking for?
Columbus Day.
So I'm trying to see what the difference between
It's funny
when a
that-
bank will be closed versus what's in 662.
Well, let's see, we don't have
Um,
Washington's birthday defined, right?
Well, isn't that President's
They
Day?
have President's Day now, right?
Third Monday. Yep.
There's 11
Monday.
up here and there's 9 in the
Okay.
statute.
Yeah, so
It's those two, because
Yeah.
there's 11 up here and there's 9 in the statute.
You're not,
the-
it's not, there's not an October in here at all.
No, in either one. So that's the in addition to our desire to have after Thanksgiving and Christmas is the Columbus Day and what's the other one? Juneteenth is in the Texas
both.
statute, yeah,
Yeah.
no, under B, not
Yeah.
under.
under B. But I think we're including some of B as well.
So what was February 17th?
It's under
Because
B.
they talk about,
Washington's birthday.
I mean, was it a Monday or Tuesday?
Where is it?
There's nothing, President's Day is third Monday in February.
Yeah, but they
President.
said, I'm just saying is that they define it as a date, February 17th, but they've talked about moving that. So is there going to be, when that falls on a Saturday or Sunday, is that going to be different from what the statute says in Texas?
I think it will be the same. It bounces around to when it's the Monday, like 17, 16, 15, 21, 19.
It's always the third.
It's always the
Right.
third Monday.
I think that'll match up.
And it's President's Day now.
Yeah,
right?
but-
Not Washington.
Okay,
Right, and that's in the statute. It says the third
They
Monday.
got
in
rid of
February.
Lincoln, right?
okay.
They made it all
They like
president.
that.
They got rid of Lincoln. They got rid of Washington.
I have a concern.
Okay, hold on, Mr.
I have a concern about one of the things we've talked about around Christmas. So, I mean, it's a fact that the banks are closed December 25th. I mean, that is obviously a day we have to have. But I have a concern about making a 3-day holiday, which banks are not allowed to be closed for 3 days, by the way. That's law. And I do not think it's a good idea for us to make 3 days of holiday that is going to queer a lot of deals, 3 days in a row is
Yeah.
going to queer a lot of deals. There is no other 3-day holiday period And, obviously if it's on a weekend that year, it's not going to matter. But on the year that it's a Monday, Tuesday and Wednesday following a Saturday, Sunday, that's out of control.
And remember, this is the one spot this appears in the contract. There's only one, is the delivery of earnest and option money.
Yeah.
That's the only one
but
right
it can
now
be-
that it has.
but it can be,
Because
that could
it's
be
on
very
the last day, so they've already got a couple of days and then you tack on another.
Yeah.
So
day.
then do you build it in up front? If you know that, then do you draft
5
the
days of
contract?
option without paying.
Yeah.
I mean, if people paid attention, but I just think we could pick one of the days, I guess, the 24th or the 26th. But if we're picking and choosing, I really am against picking 3 in a row. And here's the other thing. Again, every year it's going to be different. So some years the 24th is the biggest go-go day at the title company. Everybody is closing everything before the holiday, and they need that. And if we make that a holiday,
Well, remember, it's not just about closing. It's got all the.
well, that's, yes, turning in, right. It's about the option make, but some days it's going to be the 24th is a day that people need to not have as a holiday. And some years it's going to be the 26th.
Right. So if
I don't
I'm,
know.
if
Just
I'm
pick one.
trying to schedule inspections, over that period of time.
Right.
And
You got to calculate
yeah,
all.
if you don't take into account or you're in a rush
Mhm.
situation. So that's the only reason why I think the 24th and 26th, it's not so much for the title companies that I'm worried about or for the banks. It's really for those other issues because those are just bad days for everybody normally.
But
So I see
You mean
broadly
for like inspections or
for
anything?
everything, or just the parties getting to closing, right? It's not,
That logic, we need to go back and look at that day after Thanksgiving thing.
well,
so,
The day
I mean,
after
I
Thanksgiving.
would
It'd always be Friday.
It's always a
It's
Friday.
always a Friday.
That's a
So
different-
4 days.
So the only difference
Right.
between the statute and
Yeah.
the Fed is Columbus Day. And besides, now, then you add on those 3 days if you want to add those 3 days on.
I still
Okay.
haven't lived in your court. I'm sorry.
That would make, to me, I think that makes it easier for consumers generally.
But
On which side makes it easier?
Is to add those 3, 6, 7, and 8, and then add Columbus Day.
But in the contract, the only thing that the holiday has to do with is getting the money to
Delivery
the
of
title
earnest
company.
money and option
It's
fee.
not about other things.
And we don't extend it for,
No. It's the only
No.
place that it's,
okay, well,
so
Yeah,
for
but-
that reason,
I mean, it's a matter of just getting those done. I would think that perhaps,
Well, and it's okay. Like, what if we, to SJ's point, what if we make it less days that count? And if you're, because this is only at the third day, right? So
it's the last, yeah.
it's the last day, right? So if we do set, we don't say, the 24th or the 26th, or even the day after Thanksgiving, if you know that your last day is going to be a day that your title company is not closed, you have those other, push it forward so that you're not in
Good.
default, so that the seller doesn't terminate on you if you're the buyer.
I will throw out there, when presenting a few times ago at the commission, I raised the issue knowing it was coming down the pipe on what the commission thought about the legal holiday issue. And I believe there was 3 responses, if I recall correctly. I remember Commissioner Brown, I think Commissioner Woodruff, and somebody else. Their thoughts, and this was fresh on their minds, kind of off the cuff comments, were about when the banks are closed. Was the thing that they thought about there immediately, but that's not in depth. It wasn't thought out like we've done here, but just give a preview of what's in at least a few of the commissioners' minds. But I think we're narrowing into tying it into the bank's holidays, whether we use the government code or either way, it's the same thing. I like SJ's thought of, or May's Lee's thought of the having Trek have it on the website, right? So if there's ever any dispute, there's something there. And this is the first time we've considered it in it,
Yeah.
from my recollection ever on the committee.
Well,
So that might help.
Talked about it ad nauseum, but never
Yeah, about what
really
it
done
really
anything about
means.
it. Yeah.
So with that, maybe the concern about is what it turns out to be can be solved by that, having it online. And then we just pick this issue, solve this issue now. Is it too long of a period or not? And then if it's not too long of a period, we go with.
well, I guess the next question would be not necessarily advocating for a change on this one, but would we want to probably move to extending performance for any provision.
Just
I
wondering.
was just thinking about
Yeah.
that.
Seems to me that's a logical step that we can probably take. And-
Which is in pretty much every
Every
other contract that I've ever done except a truck one.
Well, but, okay, and I'd need to go back and look at it, but certainly for litigation, any period under 3 days, it's this same rule that if it hits on a holiday, you get another day. But any period over that, it is day by day. So, people know how to count. That's really the thought.
Yeah, so
If you're going farther out. So for example, if we're talking about an option period, due diligence period.
Right.
So if you pick 10 days and it ends on Saturday, then it ends on Saturday.
Right.
Or if it ends on Memorial Day, it ends on Memorial Day. If you don't like that, then don't pick that. Put 11 days or 9 days or whatever.
So one thing to keep in mind that we have some things in the contract today we want to send on to the commission.
Mhm.
And the legal holiday issue, defining it, I think is an issue that we can solve today or come to an agreement on. I'm not sure how much agreement and thought we can put in with the time that we have on the bigger issue of extending
Right.
all these other deadlines. It's something we definitely should consider and look at, but for today's purposes to move forward,
Yeah.
I think I would say we table that discussion there and focus on, maybe we hold back the whole legal holiday issue and look at it all together. But I think we're there to
I think we should
get
for it.
get to the end of that, and no, we'll come back to the bigger issue.
Can I make a motion?
You can make a motion.
I move that we change the language that's presented in our materials to, instead of saying defined by section 66021, that we say defined by section 6600
3.
2.003, 1 through 9, and am I doing the right thing?
So A.
Sorry, I forgot the A there. A.
You could just say A.
Yeah, just
I
A.
wish they would drop that down.
A, thank you. And then, and I am saying B7 only. I want to avoid the Christmas drama.
That's
So-
Thanksgiving.
Yes, ma'am.
Christmas Eve, or you want to?
No, I do not. I do not want to do either one. I only want to do Friday after Thanksgiving. That is the only one.
Okay, so
That's my
6.
motion.
So number 6.
Correct. B6, and that's it.
I'd say, why don't you just say the Friday after Thanksgiving?
Well, you can say that, but that's what I said,
You made a motion.
is
Second.
only.
Okay, second.
Okay.
Okay, so we have motion that's seconded. Okay. Yes, now we can, sure.
I need someone to explain to me the Friday after Thanksgiving. I'm not understanding why that should be a holiday. I mean,
Well,
the
I
bank's
think,
open.
sorry.
It's-
The
Everybody's
reason
out
I'm-
shopping.
The reason I'm
working.
putting,
What's-
so this is my motion, the reason I'm putting the day after Thanksgiving is, for one thing, as we were talking about, it is always a Friday. Okay, so I think Thanksgiving is always a Thursday. Friday after is always a Friday. So that's a known day. It is a generally recognized holiday for all businesses. That is why.
Because you think that most title companies will be closed
Yeah.
anyway. The
Yes.
deliveries will be-
Whether you can bank or not, and I don't even know if you can't, I mean, if you can bank or not, it's,
But I think the whole
It's a
issue
holiday.
is about that, because it's about paying that earnest money and option period.
Right.
We're not gonna be open.
But if they're not open
they're
to.
not gonna open to receive it.
And people
They're not gonna be open.
they're gonna wait,
Right.
and then there's gonna be issues with realtors and
But it does.
you
give-
should have delivered it,
does give
yes.
them-
However, they should have
It
delivered.
gives them more than that,
Gives them Thursday, Friday, Saturday, Sunday.
plus
Plus
the
whatever that-
Tuesday and Wednesday before.
Yeah.
Plus the Tuesday and Wednesday before, because,
If they're effective dates.
yeah.
You know, and here's the
Because it's
other,
only if the third day lands on one of those days.
right.
Yeah, so if they find an effective date Monday, they're effectively getting all the way
Tuesday,
through
Wednesday, and then the third day's the
Yeah, so if I
holiday.
represent the buyer, I'm fine with it.
Saturday,
If I
Monday.
represent the
Sunday.
seller,
Well,
And then-
and
so it's a week.
I go
Everybody
to,
has-
they can build that in, right? If
Yes.
it's known, it's there,
Yeah.
they can contract around.
Yeah,
In.
And they should.
And that's what we're trying to do This has been brought to us. That's why it's on our agenda and we've deferred it and we're having this big discussion. It is way past the 5% rule. We have been asked to do this
Yeah,
over and over and over.
I'm not
by
opposed to it.
people.
I
I
just
see
needed
lots
the
of people
explanation. I'm
waiting at,
good now.
on their heads that's something that certainly our brokers want. And we would assume that the public would want that too. So we want to give them some certainty. It's going to be known. Whatever we decide, it's going to be known.
And there's not that many that are gonna be affected by the Friday.
Right.
Cause you have to receipt on a Tuesday. I mean, I'm like, you have to do it on that day to.
And
Can we call the question?
that's, so any further discussion before we take a vote on SJ's motion? So SJ's
Point of
motions,
clarification was 662.003A, all of them, and then
Correct.
B6,
Correct,
Friday after Thanksgiving.
correct.
6 or 7.
Six.
The day after
Only.
B6.
okay, everybody clear on the motion?
Yes.
Okay. Everybody in favor, say aye.
Aye.
Aye. Anybody against?
Aye.
Tony, were you an aye or a nay?
You're on mute.
You're on mute.
He said aye, I guess,
Aye.
but he is on mute.
Okay.
There we go. All right.
Unanimous? Yes, I heard Darlene say
Okay.
yay.
If I
Can we,
make one comment, I think this is a great idea. It's going to be incumbent upon everybody who teaches classes to make sure agents don't have the misconception
Yeah.
that this is extending everything. That
Yeah.
this is only for payment of earnest money and the option
That's
fee.
all it
Period,
is.
full stop.
Right.
Yeah, I don't anticipate that being a problem. It'll just be the conversation about what days they are. Because they already understand that that's the only thing that gets extended is the delivery of those two things.
And that published list from Trek will make a huge difference.
Yeah.
And
I'm
to
sure-
Lee's point, if
The
track,
Trade Association will also assist with that, you know?
when, to Lee's point, if
Yeah,
Trek
but they'll-
can, when
they'll
they
promote it.
search on the Trek website
Mhm.
for legal holidays, can go to one of the many questions and answers that they have and have a link that could take them. We need to make it easy for the public and for the consumer to be able to see what this is.
We can ask them to do that. We don't have the authority. to do that.
Understand.
can we,
But suggesting,
If that-
as Lee did, that we do request that.
if that happens, can there be a word verified with, on Trek website? I mean, I'm just saying,
Can there be one now?
I'm just saying in there, if we know it's gonna be, if it's going to be published that way, can we put where that's being published only for the fact that
No. No, I wouldn't.
I'm just saying most agents are not gonna look up the law. They're not gonna look up.
Although I do think if they Google it, Trek is, they've been doing a really good job to commend all the staff and for all that you've been doing in educating and I've seen in the numbers that are being reported at the commission meetings, it seems this education, the contract, pushing out of our changes of just in general is getting a lot of likes. It's getting a lot of, let's say, views at the end of the day in terms of the people going to find it. And monitoring the forums that I'm on, a lot are saying, give me a reliable source. And a lot are pointing back to Trek now and all the new materials they're pushing out there. So I do anticipate that being the place that will be known quickly. Here's where you go find it.
John, I didn't include in my motion that this be pushed forward. We're going to have sort of a global.
At the end, we'll push
Okay.
for you.
Perfect.
There's a few other items we need to go through in the forms
Okay.
itself.
Thank you.
So with that, we'll continue the discussion forward. The next one I have on the list was a discussion of the seller notification of termination of first contract associated with the backup addendum. We had discussed and also with a receipt for the earnest and option fee, the additional earnest and additional option fee. And whether we should include that right on the back of the addendum itself. Right.
That is in the packet.
That is in, yeah, we don't have a form to look at for the notice. The actual, this was a deferred comment from last meeting.
Oh.
Right, so it would have been, I don't think we have it.
Lack of
in-
addendums in our material, but not draft there. I guess my question would be, what then is the purpose of additional earnest money received on the contracts themselves if it wouldn't be for that?
There's
We're on
lots
page
of different
71.
Reasons that they do it. There's lots of different reasons that we see additional earnest money.
Well, understandable, but if we already have, and I think there was a conversation about potentially adding a second additional earnest money on the receipt page of the contracts.
We did.
If indeed there was going to be additional earnest money for another purpose, and then the backup provided for additional earnest money to be paid at a future date when the amended effective date took place.
Correct.
I just wonder if people will think to go back to the actual backup addendum for additional earnest money, or if they'll think of the place they usually go for additional earnest money, which is the page of the contract.
Yeah, and to add another element, when we were having that discussion, it was if we put the additional option fee receipt on the back of the contract, is it now suggesting in introducing another problem that additional option is only for backups? There's no additional option tied to the contract, the underlying contract itself. And so then are we going to be introducing a controversy there by trying to solve the problem, which then said, okay, if we move just the additional option to the backup addendum, then does it have the two places you need to go? I think we also discussed, is it okay to duplicate it? Well, if they use the contract itself, is that okay? Does it cause any problems? Or if they use the backup addendum, then does it flow? As long as it's done somewhere, is one thing there.
Agreed. And there is another place in the amendment for additional option fee that the funds go to the seller, which is a little confusing as well. So you bring up
Oh,
an
it says
interesting
it goes,
point.
but it's not received.
That's right.
Yeah. And which adds, as we discussed, a little confusion, because then the title company needs a copy of whatever that was, so it could be reimbursed to the buyer if they close. But that's a future conversation. But
Well, and that just brings up another, how do you verify that it was mailed to the seller? I mean, the way they've written it, because everything goes to title and it's all verified, but then the additional option money says go to the seller. How do you receive that? I don't know.
You don't have to receive it because.
That's what, yeah.
Please.
We're talking about two different things too.
But how do I know if they sent?
Hold on.
Were you proposing that we have a form that is the notification and that the receipts are on that?
No, there's two
Okay.
separate issues there.
Okay.
There was a request that we deferred for 2 meetings now on a request for a notification of termination of the first contract. So that's one issue. And then we have these receipts. That's a separate issue.
Okay.
And I would throw in one other one is the capitalization of, it was option, I think it's option fee or earnest money. It's capitalized when it's not defined. And so making that lowercase to be consistent was one of the comments at the last
So
meeting.
follow-up question. I know that over the years, we have had public comment asking for some kind of form for notification. However, I'm curious, are there lawsuits out there because people don't know how to notify each other? Are there settlement? I mean, is it true? I mean, it's never been a problem for me, but I realize it may be a problem for others. So is it really a problem, or is it like 5 people in 12 years have said, hey, what about a form?
So what I've seen in my personal experience has under the old way, it was raised a couple times, but spotted. When we came out with the new addendum, I think there's more of a laser focus. And the questions that I get are, what form do I use? How do I get, what's the actual proper notice? And part of the discussion is, well, there's lots of different notices in the contract that we don't provide, right? And we have notice of termination on each side and, limited other things, but we don't get involved. We haven't historically got involved in all these other ones. And now that there's a focus on this particular one and the deadline runs, it's a really important deadline. This is where my mind tips to, it might be worth doing the form. And I'm kind of leaning on that side of the fence of doing it, is because it's the date that establishes when all the deadlines run from. Unlike these other notices that may do X, Y, Z that are, whether they're termination rights or something else tied to it, this is the new effective date. And it's not when the first contract terminates. It's when notice is given by the buyer to the seller. And having that in writing somewhere in a consistent form that's not an email, not a text, something that they could, we had as, here's what you go look at. Now, would a text still be sufficient? Would an email still be sufficient? That's a fact, the case by case basis. I would argue in most cases probably, but you wouldn't have a nice clean, here's an actual form that establishes the new effective date that was provided.
I agree with you. I think realtors are used to using a Texas Realtors form for that purpose. And if we can incorporate it for the non-realtors in a form for that notification of what is the amended effective date, it will simplify things and it will be a direct form. So I think you've got a really good point.
Will you entertain a motion one way or the other, or more discussion on that? If we want to get forward and move the notice.
So going along with what both Lee and Diane said, so yes, we use the Texas Realtors form for this notice. How much, just from the broker's perspective, how often we do talk about backup contracts. We do a number of them. We use the TXR form. How widespread do we think this affects everyone for needing a form for us to actually put one together from Trek versus utilizing what Texas Realtors has out there? How many people does this affect needing this? I'm just curious.
Yeah. So there's not, I do a backup contract and then I have to convince the title company to take it with the earnest money. Right? Because we do more backup contracts now than we used to, right? But I'm not sure that there's 5% just backup contracts, much less this necessary follow through, and necessary for sure. So, I think you make a legitimate point. I'm not opposed to it. I just am not convinced of the need.
Okay.
I think it is probably less than 5%, and there is a workable solution for it.
But that's
not
not
every
from, that's not
contract.
from realtors. Our license holders still have to.
And the industry's evolving with a lot, in terms of the numbers and I think these are guys, but we can't in the decisions rely upon that being available. Go ahead.
I think that less than 5% is increasing because of the clarity of now having a form where the agent doesn't have to mess around with special provisions, which is what they were doing. I think we've given them the tool to keep themselves safe, and maybe the amended effective date and an additional box for the additional earnest money and additional option fee. There's really going to need to be two, depending upon how the form is used. And then that amended effective date could potentially be on the back of this form with the education to the agents of this is how you notify the listing agent when it goes into first place.
That's an interesting thought I hadn't considered. And what I believe in, let me know if I heard this correct, of not having a whole separate form. Let's just build it into the form that we have as like a receipt that just has the new effective date. I like that idea.
Keep it simple.
It solves two birds with one.
You were talking about adding that to the backup addendum?
As on the back of it to have almost like the receipt page of just the notice built in as a box. And that way we don't have a wholly separate form.
We have it on the bottom, not that
Going
many
back.
Just like a receipt page though, if you had the additional
The
option.
receipt page is after the signature line.
Well, we could
Right.
use
got room
You've
for
gotta get
after the
notice.
signature. The signature lines up and have a receipt.
Well, it's a notice of
Doesn't
you would
the
have to
title
give
company,
it.
doesn't the title company have to get a copy of the notice of termination?
No. So the title company,
What
it
if-
depends on who's handling
What
the
if I'm,
contract.
if I'm the backup buyer, I just send the money in without it?
Line is still in.
Well, some title companies
Well-
won't hold it because
Got
they,
too many people talking at one time.
Diane,
some title companies in our experience will not take
hold on.
the backup contract because they can't open two GF numbers on the same address. So some will deposit it, some will hold it. But we want the agent to get it to the title company so it's real, that it's actually there. So I think that's one separate point to our conversation on the form. There's plenty of room to bring this to the front and then move the signature lines down and kind of copy what we have on the receipt page of the contract to give the amended effective date the acknowledgement. Now, the question there is going to be, will there need to be signatures by the parties? Not to acknowledge agreement, because it happens automatically that there is an amended effective date.
What I'm hearing Ron say, which may tie into, right, yeah. Go, Brian.
You know, I hate making slippery slope arguments, but this is one of those situations I will. We have good contract forms that are usable for the public. They're not intended to address every single little permutation, negotiation, or other things that might happen in the course of performing a contract. That's why there's a trade association that provides support to their members, that provides value. But I don't know that it's the TREC or the Broker Lawyers Committee job to come up with a different little form for every different possibility. And there's a workable solution. And if you're not a realtor, then you need to get a lawyer to help you draft whatever it is you need to do. But I think this is expanding a little bit too much the job of TREC.
The comment I'll make to that in time, also with what Ron said, is even the license holders that are members of associations, when at the title company, I saw a lot arguments over the amended effective date because they weren't using that form. Even though it's available, it wasn't for whatever reason used, and it was an email or a text or something that, hey, here's the date I actually told you, other from the listing agent to the buyer's agent, saying, here's the date I actually told you. And they were arguing over that. And so that's where I see it come up in a lot of different contexts. And to throw in just a point that Brian has said, just get it on the table, adding it to as part of the contract and making it there. I see your point on the receipt page being different. And I think that goes to the receipt discussion as well, if we add it to a separate receipt page or what we do, right? And I think having that additional option fee receipt somewhere, if we want to keep it separate from the contract, it wouldn't go on the backup addendum.
Right.
Or it'd have to be a whole separate page on the backup contract addendum, or, inserting it into the main contract raises that other issue of the, circular concern on, is that going to then make people think they can put up additional option money?
Well, the receiving of additional option money, I've never had a problem, because title companies are usually prompt on sending an email back that says received, when, additional owner's money received. I rarely had a problem. It doesn't happen almost immediately.
And with everything going electronic with emails, it's very easy to establish which date is the amended effective date. It's not going to be in dispute.
Just a last comment. TREC's responsibility, their mission statement is to protect the consumer. And I think when we have realtors that are not members of a trade association, and that question of what the amended effective date is out there, that's part of the reason why the conversation got started with the backup addendum, for clarity to when is the money due, how is it delivered, and that amended effective date, which I don't think we thought about at the time when this was drafted, that I don't think we should leave it up to the non-realtor member to go to an attorney, because the consumer doesn't want to spend the extra money. And if we can add one line on this to say that and add clarity, I think it might be a good idea.
And my personal thoughts are, I think, drifting away from where I see the majority is. I'm more on Diane's side of thinking this is a notice we should do. I'm still mind keeping it simple of a separate notice that establishes a lot like the ones that are available in the association. Or, and I agree with your, the 5% rule, I think, is applied in my mind a little differently this way. Even though we're looking at it, all these transactions, only very few have the backup addendum. I look at the 5% of those using the backup addendum, look at the 5% of that, right? So it's kind of a derivative of that. But I would go around, I'd share Diane's concerns. I'm feeling like we're in the minority here overall, and to continue the discussion going forward. Does anybody have thoughts that are coming over to ours? Are we convincing anybody else to
Well, I have one comment on that before you throw it out, is since this is a broker and title company issue, mainly a broker issue. The question is it necessary to the brokers? I mean, the form itself is simple. We can draft one in a minute.
Right.
Yeah.
I have a question in regards to what you're talking about, John. If you're saying that we do put together a notice, and in the current addendum for backup contract under H, it talks about seller must notify buyer immediately of the termination of the first contract. Are we saying that a notice we put together would be the mandatory, only required notice that is allowed to be used? Because we don't, in my opinion, if I'm thinking this through logically, we don't solve the problem if it doesn't be the required notice, and still any notice can be used. So if a agent is not educated about how to do it, we're still going, or it's not the only form, we're still going to have the same issue.
I think that-
They have to be able to text each other and.
What I'm going to say this, and please kick me if I'm saying this incorrectly. I think, but it's a if it's a mandatory form, right? That's required to be used by the agent for that particular scope for which the form is promulgated. That is separate from the legal analysis of whether a notice is effective for legal purposes. So if an email sent with the notification from the agent to the other side, or if they use their own form, like a Texas Realtors form, which they shouldn't have one if there's mandatory use, I believe, on this, but let's say they use some other one. If for legal purposes to establish the amended effective date, I think that'd be okay legally. But it's an issue because the agent for Trek disciplinary matters and for their license having used the wrong form. And I know this is subject to some ongoing things, so not, doing an opinion on this now, because I know there's some active lawsuits over this, but that's my general understanding. And it establish a legal standard as opposed to the disciplinary on the Trek side. And I don't know if we can comment on that, but if I'm way off basis, then that's great.
And, too, we always tell agents if it's not in the contract, it's not enforceable. And so if we've got emails hanging out there and that establishes the amended effective date, that doesn't seem right.
And that's where I see it. I saw it a lot even before we made the change. At the title company, I saw arguments over when the amended effective date was on because of emails, because of text. It seems to have drifted over more text than emails lately, but now it's even a sharper focus.
Still want to raise another, I understand what you just said and the law and everything, but still when we're talking, and I'm not trying to get off subject here, notice of buyer's termination of contract, they don't necessarily have to use the termination that we have promulgated. They can still send a text to terminate the contract. And I know there's some gray area there, but we were just talking about, of course, the legal cases last time we were here. So that's where I want to know, does it solve the problem that is on the table if we do this? Does it really solve the scenario at all?
It provides a solution to me, reduce controversy, right? If it's known, like we're talking about the legal holidays, if it's in there, they can go to Trek and say, here's what it is, right? It's kind of, we're going to Trek and there's a form for it, right? And so it could get out ahead of time, especially for those that do not have access to the association forms, right? And that's a growing number that seems to be happening. But it's not going to solve everyone, but it's a known issue. And how big the issue is, I think, is subject to debate today and what needs to be done.
Okay, John, so let's say we do something. I'm the listing broker. I'm the listing broker and you're the agent for the backup broker. And I send you an email saying, hey, the first contract dropped out. You're number one. But I don't get to fill out the form. I don't fill out the form, but I sent you an email.
Mhm.
Was my email effective?
Yeah.
Darn straight it was. I don't have to use the form to give notice. Okay, the establishment of the document we have for filling in what the amended effective date is a tool to help people memorialize something. And if the other side disagrees as to what the real amended effective date is, it can be argued over. Okay, that I think that the law is pretty clear on that. So, yeah. I don't know that there is tremendous benefit to us having a form that is a Trek promulgated form to do that. We don't have forms for making title objections. Do we? Do you want to do that? I don't want to do that.
There's been lots of requests for that one too, but yeah,
Yeah.
and that gets into, and that's, yeah, that's just
I don't
scary there,
think
but
you
that's.
have to have it. It's nice to have something, but giving an email saying the first contract dropped out, you're now number one, is sufficient to satisfy the backup contract requirements. And then to memorialize what the amended effective date is. I mean, the contract, the addendum says what the amended effective date is. It says it is the day that buyer receives notice.
To throw in some, and not to cut you off, but you can continue on, an email may or may not be effective. It's paragraph 21, that whatever written notices you give, now in most cases, you can argue an email would be effective received and all that, but we have to be careful for anybody listening to this later, you should follow the notice requirements in paragraph 21 for any legal notice under the contract. And if whoever's listed there, or whatever information is listed there, that's where legal notices should go to. There's legal arguments that in most cases, I think email that, trump what's in the contract, but that will be disputed, and you don't want to end up in court fighting over whether you gave proper notice or not. So make sure to follow paragraph 21. But want to get that in there so anybody listens to this later, the 3 people that will.
Well, we could get into another argument as to whether that is or is not an effective notice. I think it may be, but
I think most cases it will be.
I think it is absolutely wise, if you're going to give a notice that is to have legal effect, then it is always wise to follow the notice provisions of paragraph 21.
John,
Yes, sir.
I want to clarify and correct something that was said a minute ago by Diane. So you said our mission is to protect the consumer. That's not,
The commission.
Of a legal to class.
well, whether it did or not, the statute actually says, and there may be additional rules and it's part of it, but the duties of the broker lawyer committee, in addition to other delegated powers and duties, is to draft and revise contract forms that are capable of being standardized to expedite real estate transactions and minimize controversy. That's really, and part of that, yes, is taking into account that these are out there for the public and whatnot, but, it's not just, protect Joe consumer. We are really trying to minimize controversy and standardize transactions so that they can be expedited, and that's what we need to do. So is this following that mission?
And that's our directive there, and I do believe Diane is correct too, is the commission is consumer
That's one.
protection oriented as one of their main missions, but it's all well taken in terms of the going forward with what we're doing today. We're minimizing controversy, we're protecting the public,
So if it fits,
and that's where I want to circle back around, right? Continue this meeting forward, because I was trying to get us out at a decent time. And we're starting to circle now, right? And that's where I think I share Diane's concerns. I share her thoughts on this and the details of how that comes out. I don't know, but I am feeling we're limited on our side and compared to the others. But Ron had a good point to the brokers who, Lee, I think you said you kind of flipped to think it's not needed at this point.
I just don't think it's necessary. I mean, yeah.
And title, doesn't think it's necessary here.
I don't necessarily think that we need it yet. We may at some point in the future, right? I'm not saying no forever, but I think that if we do it, back to what Christy was saying, is in paragraph H of the backup contract where it says seller must notify buyer immediately of the termination of the first contract, we would have to say by using form blah, 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 if we make a form. Because otherwise they're just going to keep emailing and text messaging each other. We're going to have to be super clear that this is how you do it.
but that's
in
not
here.
I don't think you can do that because you're essentially making law. If you say that, you're making, it's the law of the contract, and I don't think that is not even Trek's purview to make new law about what is and what isn't a contract and what, and this is the only way we can do that.
And you make it more likely.
That is making more controversy.
Okay.
Now we do have other language, and I think we'll get past to say, we'll go over that actually references not you have to use this, but here's an available form for it. And so there's other precedent in our current contracts and some of the language that we will be going over today. So we'll circle back around to that. And
But my vote for now is I don't think we need it yet.
okay, so we'll move on from the notice today. We'll keep it on the agenda for
again.
We'll defer again, because there's still some hope. If you're listening,
Try to do it again.
Sounds to me like there's not really.
hey, y'all two are off today. This is blood in here. I'm gonna start politicking.
A last thought to take with us. The 5% rule, when it comes to backup contracts, and I work for a very large company that does a lot of transactions, it changes with the market. And when you've got multiple offers, they are used. It is a tool and it protects everybody. So.
Point well
True.
taken on.
I will add one more thing to that. Very large brokerage here too. And we do a number of them, but we're members of Texas Realtors, and we have the use of the form that they have available through the trade association. And those are the ones who really know what they're doing on backups. And we do have something available for that currently.
Yes.
That's all I'm going to say.
So we've got the protection. It's the 50,000 other license holders who don't.
They
Or,
aren't even showing.
or the
something if
public.
It's already.
Yeah.
Correct.
I mean, this is,
Write it without the.
I just don't
anyway.
think there's enough backup contracts to justify this lengthy discussion.
And so
How we done.
going to maybe quickly back to the receipt issue. Are we feeling the same way on the receipt issue? Is there, Ron, you brought up, and maybe I teed up to you first, on the title companies sending emails to confirm?
Again, this is a practice issue, so I'm going to defer more to the title guys, to the brokers there. But to me, in my own, I've not had an issue when that's happened, when we require additional earnest money for whatever reason. It comes in, it's getting quick receipts from the title companies.
It's the easiest thing to do. I mean,
Receipt.
so many of them have just a receipt that they generate from their system.
They're not
Saying the
signing.
contract is completed.
Or somebody will say, hey, did you get the earnest money?
We got it. Yeah.
We got it.
if that happens though, and your company requires some verification, that's the other problem, because they'll say, give me the receipt of the additional earnest money in your file. Is it then okay, just a copy of the email? I mean, if it's verbal, it's really messed up, because you go, well, I talked to the title guy and he said yes, but I'm saying agents like underneath her, this is required to close the file, you know.
And we do require those, an email from the title
There you
company's
go.
devices for our compliance.
So then how do you have to receipt it somehow. It has to be receipted, somehow through DocuSign or something, or a copy of whatever that is, Zucam or Zocam or Zocam, yeah.
And Dan, I'm going to come around to you. I'm feeling you may share the same thought I do. And I like the receipt, adding it, but I know I'm in the minority here, so I'm not going to belabor the point. Do you want to give any thoughts on that before we move on?
Well, I think back to what commented earlier, some good points were brought up, and to make sure that everything is all in one place. The receipts and the amended effective date in writing agreed to by the parties, just protects the brokers and consumer.
I agree.
And so I think that that's one of the goals of our committee, to think of protecting everyone and being complete. So I guess we'll just come back to this again the fourth time.
So,
And I do believe the receipt is, it's required. I mean, I'm not gonna get paid unless I prove to whoever is in charge.
so are you on team include the receipt or on there?
I'm include, some way include receipt.
Tony or Darlene, any thoughts on this issue? No?
Audio, just-
No,
He's gonna give us.
Muted. Sorry. It's not something that's come up often with us as an issue, but I can see the other side of it. I mean, it's not something I have to settle very often in our office. So we don't mind doing a receipt, and we do have a stamp. We can receipt it on any form you want. So it's not a huge deal to us. I think it's more important for the realtors and the customers.
Okay, right.
I wouldn't want a separate form. I would not object to putting it on the end of the addendum for backup
That's what
contract.
I'm thinking.
For just the option money
So after
receipt?
the signature.
You could do the option money, the additional earnest money.
Well, I have an issue with that. I'm worried about that creating confusion that at the
That's
time of the
that form
backup,
as opposed to the other form.
right, as opposed to the notice.
And I guess I wouldn't object to putting below the signatures, seller has notified buyer of the termination of the first contract. The amended effective date is blank.
We already convinced one more, Diane.
I don't-
We already have them converted. We did, but we're on the receipt side now.
I thought,
Ron has a concern.
what we could do, if you wanted, is to have you just add to the additional earnest money receipt that's already existing, check boxes that says pursuant to 5A, whatever it is, or 5B, backup addendum, other. And then they
That's
can-
I
interesting.
like that.
That's.
The lame duck here. I like that.
I actually like that. That's,
We're gonna just keep
That's-
talking about this until.
no, we're on the receipt. We're on the
Yeah.
receipt side right now.
I mean, I don't know if there's a need for another, I mean, you could kick out a blank receipt and just,
It happens all the time.
Yeah.
Do a receipt.
You know, and I will say this page usually comes back with a separate form from the title company. They seldom receipt it on this page.
No, mine just keeps adding.
So to move forward today, what if we, 'cause this isn't a urgent emergency issue. We've already moved on a little bit past. What if we look at that for the next meeting? Come with a suggested language. Diane, maybe you and I can work together on, or the, Christy, are you on our?
I am, actually. I would love to be part of that conversation.
Okay, yeah, so we'll take this back to the subcommittee.
Aren't the back?
Did we add you? I think we did add you at the, I'm gonna go back to the minutes.
I just got sucked in.
Actually, I do have a list of who's on that
I'll
committee.
chat.
It is I do not have Melissa, but we'll gladly add you to it. That's,
I think I just got voluntold.
yeah, I have her on the compensation committee.
Yeah.
But-
On the disclosure.
But you're welcome to join us as well. We'll have that, but let's meet and let's see if we can come with a proposal for the next meeting. on-
Melissa,
on
if
that.
you're a lame duck, you don't get something.
Okay.
Hey, there
Uh,
you go.
Marching
We got 10 years to
forward.
go, I think.
Okay.
Capitalization.
Oh, capitalization is the next one. So right now, if we look at like the earnest money, there's a defined term for option fee. We'll start there. On the receipt page, I'm on page 11 of the materials, if you want to look at an example. It's receipt of blank dollars option fee, right? So we have a capital O, capital F. And then in our backup contract addendum, it continues with that same capitalization. I can find that again.
71. Yep.
Which refers back to the original option fee, right? So if you look on A2 of the backup addendum, we have buyer should deliver additional earnest money of blank and additional option fee capitalized of blank. And during the last meeting, we had a comment come in from the public and briefly discussed it, that we really could remove the definition and have lowercase o and lowercase f, because that's the same thing we do for earnest money. Earnest money is not capitalized, and there wasn't a reason that I know of that we would have capitalized option fee as something different. So I think the simple solution there that I would propose is just removing the capitalization of the option fee.
Yet in paragraph 5 of the contract is capitalized.
Right. We'd fix it.
Yeah.
We'd fix it everywhere.
Yeah, so in every spot that option fee appears, make it lowercase.
Because our conventions, of drafting are that if it's a capitalized, and that indicates it was a defined term and we defined it somewhere.
which is on the receipt page right now for option fee. But we
But
don't
we
do the
could-
same with earnest money. So earnest money is not,
Note that on the earnest money receipt, we do capitalize
Yes.
earnest money.
Yes, but it doesn't really say anything other than, I mean, that's the weakest definition of anything in the
So
world.
help me understand the consistency of it when you're looking through option period is capitalized. Many other things are. The only thing that doesn't seem to be is earnest money, yet it is hugely important in the transaction. So why are we
It's not defined.
minimizing option fee? Why don't we capitalize earnest money when you look at paragraph 5?
It's not a defined term.
Or they defined it.
Earnest
What
money
is the
is not-
definition of defined term?
It
so
means
if
we define it in the contract.
so look, if you look on 71,
That's a defined term. in
or
the-
actually 70,
Or in.
or excuse me, is it 11? Let me see. The receipt, on the receipt page, on page 10 of the contract, page 11 of our materials. That's a defined, that's where we actually define option fee there.
Right,
And it has the parentheses, option fee. And the concern was raised because in our backup addendum, it uses that capitalized option fee.
That is the definition, but that's the weakest definition. I mean, it's not even really a definition. I agree with whoever sent in that comment that that's not even a proper definition. Option fee is not a defined term as that, as that term is known, so it shouldn't be capitalized. It doesn't mean it's not important, but option period is defined in the contract, and that's why it is capitalized.
So just a comment. I'm thinking of who reads this, and it is the consumer and it's the agents. And so much is capitalized. And then we suddenly choose to take an option fee and make it lowercase. And it just seems that it is consistent to the reader, in my opinion. I'm not saying that your legal answer isn't 100% correct. I'm just saying, does the reader understand that and
Sure.
define term? I'm sorry, I don't.
And if you see a
They don't
capitalized
understand it.
term,
That's why it doesn't matter.
you see a capitalized term, you can go find it somewhere. If it's not capitalized, it's not somewhere in the contract defined. It's just a regular word.
Yeah, I
The
think
one
the point is that having it capitalized when it's not defined creates confusion.
It does.
It sets it apart. It makes people think, well, am I looking for a definition?
And it's
somewhere?
against our convention, which is a rule, and it's not just for this committee, and it's not just for lawyers. I mean, we had this weird discussion last night about certain conventions of how proper writing is. And in any
Yeah, not in
time.
contract
Right,
associated, just in general.
General writing in
use of mouse,
English
but
grammar.
the two things that might help, at least me get over that hump, because I see, being defined, having it there. Right now, earnest money being it's only capitalized in the receipt page, but it's not defined anywhere through the contract. And this has all the contracts, but it's referenced 293 times in our materials, and through all the contracts, and it's all lowercase. On there, right now with the receipt page being the only place that option fee is technically defined as being below the signature line, arguably not part of the core contract. And so my concern about confusion one thing we have to correct right now is the backup addendum and the confusion created by having that defined term used for additional option fee. Because it doesn't make sense there. It's defined as a receipt page, carry that over. That doesn't make sense. That would need to be corrected. The more simple correction that would cause less confusion, I think, is just removing that definition and making it lowercase, because there's only a couple places that it appears capitalized, and nobody's ever had a confusion over that fee that I've had raised until we modified the backup. Talking around circles, but I think doing this other thing is the least of the evils, right? We can do it either way, but I think making it lowercase would be easier. That's true.
I just want to make, I said just a minute ago, we had this conversation last night talking about capitalization. I want to clarify that that was not a meeting of the BLC. There were a few people in a conversation, actually
We were talking about
we're
geeking out on the mouse.
talking about an English major
Yes.
and using that degree. And then the conversation just was about general writing, the Oxford commas and general writing. It had nothing to do with this committee. But some of the people who were in
And
that
for all my law journal
conversation.
peeps, the blue book should
There's
be on
that.
everybody's desk still. Yeah.
So no walking,
One,
yeah, no walking.
one minor comment.
Chicago Manual.
Sounds like we're now moving to lowercase for it. Can we, I'm not sure why we have a parenthetical there
On the receipt
on the
page.
receipt.
I was
We
wondering
say
that
earnest
too.
money doesn't have a parenthetical.
Oh, yeah.
Right. And well, in
So we
earnest,
remove the parenthetical.
yes, yeah,
Well, and
they-
earnest money shouldn't be capitalized
correct.
on the receipt page either. That's just an error because that's inconsistent.
Everything needs to be.
So I don't know if you want to add the word
Lowercase,
as
lowercase,
the
no
option fee,
parenthetical.
receipt
Yeah.
of
That's my vote.
blank
too.
dollars
Saying.
as the option fee, or to me, those two things should be
Similar.
consistent. I don't mind
Yes,
putting
exactly.
the parenthetical lowercase on both of them either.
I don't think
It's
it
a minor
helps.
point. It's my point, but
I don't think
Agree. You want the
The
parenthetical?
I don't want-
I don't think it helps.
No, I think we take
think they
it
would-
out.
Move the parentheticals, everybody lowercase. Earnest money shouldn't have, that's
Yeah.
just an error that we let get through some time
So-
ago.
Do we just, have receipt a blank option fee, this lowercase and leave an option? Not, I don't think we need to as a, or as.
Right.
that's fine.
Remove the parenthetical
That's fine.
and then lowercase and lowercase on the earnest money in the both places that it exists on the receipt page. And here's funny. Okay, have we defined contract?
I looked at that too.
Yeah, have we defined contract?
Contract is lowercase in all, I
Should
was
be,
looking at this
yeah,
on
it
a
should be
separate
too.
issue for
And
the
not
buyer
receipt page.
representation agreement. And
So
it's-
contract ought to be lowercase on the receipt page as well.
I was a little surprised contract wasn't defined when I was looking at that, the past week.
Really?
Mhm.
Because I was surprised when we spent 4 hours defining as is.
That deserves a 2-day meeting to define as is.
It's just
It's been
about,
done.
um,
It's been done.
Not since my
Add it up.
time. Okay. Let me know when you're ready, Ron.
so do we need a motion on that or anything? John, are we all in agreement? Everybody's in agreement?
I think we're,
We should.
well, we can do a formal motion to have.
I move that we remove the parentheses on the receipted page and go with consistency and lowercase for contract, option fee, and earnest money.
A second.
All in favor, say aye.
Aye.
All against, say
Aye.
nay.
Thanks, Darlene.
Did we get a thumbs, Tony?
I saw Tony, I thought that was like a
I
sash.
like it.
He's
He's
an elbow.
blurring out his thumb, as if it's not a thumb.
John,
Yes.
No other fingers.
while we're talking about uppercase, on the backup addendum under H, it's referenced to first contract in a couple of places. Does that,
I think that's an actual defined
That one's
term
defined.
there.
Yeah.
The backup contract.
So in the addendum.
It's defined as the backup contract in A. And
Well, the only
G.
thing that you.
We do.
G, thank you. And then it's defined as the first contract in G, yes.
So should we take the "the" out though?
No,
Because we don't have "the" in any
it's in there.
first style. For
It's in the, every time it's used, it's the first contract. E's okay. I mean, we could take it out, but why
I don't
at
want
this moment? Do you want to?
No, it's okay. We have a past motion on this issue, so I think we're gonna be looking at that as a subcommittee to
Yeah, just
to redo
clarification.
that. We're
Straighten
gonna
it
look
out.
at clarifying that. Okay. Are you ready to move forward? All right, marching forward. If we take a maybe 10-minute break and then come back, so it's 10:25. We'll take a 10-minute break and come back at 10:35, and the goal will be to wrap up around lunchtime.
Always have a goal.
It is 10:33. We're back from break here.
Oh,
Yeah,
wow.
that's great to see. Welcome to all of our guests here.
It's almost like that meeting when we did paragraph 12 for the first time.
That's
Yeah.
Okay, so the next item, we're still on the deferred items from last meeting, the whole purpose we call this meeting for the most part. We have a comment that we deferred on the broker information page. And right now it has other broker listed on there. So we had to discuss what to use potentially for other broker to clarify who the other broker is. We have a listing of a sub-agent on there with the new Senate Bill 1968, which has officially passed. It wasn't technically signed by the governor, but it passage of time, it's now law. And it will take effect January 1st, 2026. Part of what that bill did was remove the one place in TRILA that referenced sub-agency. And instead of sub-agency now, we're going to have a non-representation status where you can do this sole brokerage service of opening a door for somebody and to allow that person to come in, prospective buyer, to view the property.
Keep your mouth shut.
And keep your mouth shut. Thank you, Mary. That is the biggest thing, because no advice or opinions. There's limited things you can confirm, like square footage, what color carpet maybe, basic things you can confirm the details of, which are in the statute. We're not going into detail right now on it, but no advice or opinions. But there no longer effectively will be sub-agency in Texas, as we've known it for now a long time. And so part of the clarification is removing the reference to sub-agency, having other broker being changed to buyer's broker. And actually, Diane had a sheet with a markup much better than I brought to the other changes to clarify where there's some inconsistencies on that page. And so, and then.
Were there multiple copies or?
Yep, actually there. Let's see, thank you, Diane, for bringing these. Everybody take a sec to look at this. Another 10, 15 seconds, and then Lee will have the first comment.
I know. Well, I don't know.
What I'm understanding is.
All right.
We're deferring to your wisdom.
Yeah.
Okay.
Yes, I promise.
Lee, kick us off.
So, does the new statute define, I mean, is there a word for this relationship? I mean, I know in other states we have, facilitator is in their statute, or, some term. Do we have, I mean, obviously we got rid of sub-agency, but if there is going to be the option to not represent anybody, what is the term for that? Did they name it?
No, there's not a defined term to say this.
Okay.
It's referenced, to the best of my recollection, and I have it right here, of a license holder who represents a party under X part of the statute, or not represents, sorry, that opens a door, performs services under X part of the statute. And I'll get the exact English here. So it's kind of just a reference back to the statute that allows you to open a door without representing a party.
Okay, so say that it's statute number 1. So it's like statute 1 agency.
A license holder who performs any act of real estate brokerage for a prospective buyer of residential must enter into a written contract. And then it has the next language.
Read this. I just don't remember I don't think they've labeled it.
Go up.
Yeah.
Okay.
Okay. Thank you. Yeah. So then it has that where it references back, you do real estate brokerage or you do not do any real estate brokerage other than.
Show.
that part of the
Okay,
statute.
so for the license holders, which are not the only concern, y'all. But for the license holder, I think if we tie it to representation, like with or without representation, that's gonna make more sense to them. You see what I'm saying? Because
Well,
they
okay.
understand if they represent somebody or not.
At this point, you're not going to have without representation.
Sure you
Yeah,
can.
you can. You have 14 days.
Well, not on the contract side though.
Not on the contract, but on the
They can
statute. we do.
without representation and still be working with a realtor, or pardon me, a license holder. They can be working with a license holder and make an offer and not have representation.
But I don't think so under the statute because the sole brokerage activity is opening a door and that's where it stops. So there's, and it's true non-representation.
But you can have a buyer broker agreement that does not, that where you get paid
You're still an agent.
and you don't have representation.
No, you can't. If it's not, the only thing for non-representation is the door. Literally opening the door and showing basically that, but you can't do anything else. You can't give them any advice. You can't tell them about a contract. You can't do.
Talk about school.
Okay, let's make it, I'm not a proponent of a consumer writing an offer and working with an agent and not having representation. I'll make that clear. However, you're saying that the statute takes away their choice?
Yes. They all-
If-
They no longer can make
Well,
the choice.
No, you can,
for
but
the
then you're
agent.
representing at that point. So you're either representing or you're not. And if you're not representing, before you can do anything on their behalf. Now the statute said you're not representing them just like you did before, but we're allowing you to do one simple thing. And that one simple thing is opening a door, but you're still not represented. And it's weird because you have to have a written requirement now,
Yeah,
but it says we're not representing you.
but
Well-
let's say I'm a consumer.
Okay, this is what the law now says, right? So this applies to residential properties, right? And then it says, a license holder who performs, I've got something. blocked.
Any act of.
Any act of real estate brokerage must have a written agreement,
Sure.
okay?
The
Then it needs-
in the section above.
Right, but this, what you're talking about is, do I have to represent the buyer if I'm doing services for the buyer beyond showing, namely writing a contract form? And the answer to that is yes.
Yes,
Even if the buyer doesn't want that.
yes.
Now, you can say to the buyer, I am going to perform limited services for you, but I do represent you.
But it's a service. Yeah, it's a brokerage service.
That's what I represent. So if you hire me as a lawyer and all you want me to do is draft one little thing for you,
You're
I agree, then you're going to limit me to what I'm doing for you.
Right.
Yeah, right.
I want
Right, so I mean, obviously I'll be following the rules, but I will say I'm very surprised that we've taken away the consumer's choice, even though it's a bad choice for them.
Actually,
I think it's
it's not a
taking away the
change.
choice.
Actually, it's not a change.
Well, you can still give them the contract. They can fill it out.
It's not a change. When
Not a change.
when
You ever did
under the
any
previous
brokerage service?
statute, when
You
you
represent-
engage in real estate brokerage activity defined by the statute, you are acting as that party's
That's right.
agent.
Whether there's a contract or not, whether there's a verbal agreement or not, if you do it, it is representation.
And I wanted to be clear for the record, the trigger of the new written requirement is before submitting an offer, right, on behalf of that party, or before doing any other act of real estate.
Right. So I think for this
Somebody read-
purpose, we're only talking about who is the guy on this contract form representing.
Yeah.
And the other broker is going to represent the buyer. So my preference is just call him the buyer broker.
So it's before, there's theory, yeah, and I agree. I think that at that point, you have to represent because you're helping them with the contract.
Right.
Right, and the trigger though is before touring or before submitting an offer. So there could be a little period of time there that the statute doesn't require a written.
Yeah, and I'm not-
It's such a tiny
Yeah,
little
but this
period,
is,
but practically you're gonna have to.
yeah, but this is identification of who I represent.
Correct.
I want to make sure I'm clear. I have read this, but I want to make sure I'm clear. So even with this new bill going into effect, even if it is a listing of an agent, even they can open their own door of their own listing
Oh, they
to
can.
a buyer. So this does not, the way I'm reading it, I just want to make sure that they can open the door to the listing. So I want to understand.
When I read it, I thought I understood it too.
That's
but
a
they
different
just put it
section.
That's
To
this is
show.
why I'm going and asking this question, because the way I'm reading it, I can read it multiple different ways. So if a agent has a listing, they cannot even open the door to their own listing
No.
to another buyer without a buyer agreement.
That's a different,
It's for the listing.
it's a different section.
It's for-
Okay.
This one
Yeah.
here.
Okay, different section.
And so one of the part of the notice that's required, and it's to me, the most confusion I see from the statute, if you read the part up above first, it doesn't sound like a written agreement's required.
Right.
And then it goes into, well, it is required for residential real estate in almost every case. And part of the notice that has to be provided, whether it's in the new IBS that will have to come out or the new representation agreements, says whether you represent the buyer or not, and if you're representing the seller. And so if you're either intermediary or only representing the seller, it is going to have to be in that contract, that written agreement with the buyer. So that, I think that will help clarify on if I'm only here opening the door on behalf of my client, the seller, not you, Mr. Prospective Buyer. I think that's a good part of the change.
Okay, and I want to make sure that when we're talking about the listing agent has listing, they open the door, they're very clear that they're opening the door for the seller. There's no changes as far as intermediary with or without appointments. I want to make sure I fully understand this as we talk about this.
No change at all to the intermediary requirements through the change.
Okay.
The only thing you can roughly say on there is a new notice that be provided that essentially I represent only the seller, being part of the notices that are provided to the buyer.
Okay.
Just for my edification, if I'm a listing broker and I have an open house, and somebody walks in,
That's why I don't.
I represent the seller,
Seller.
and
Mhm.
I'm not your agent.
Okay.
But isn't this a beautiful house? Look at this and look at that, and the school district is to die for. Am I violating
No,
the provision that says does not provide to the party opinion or advice
No.
regarding? the real estate?
no, that's a different
Yeah,
thing.
fine.
You represent the seller.
So
Open
it
house.
becomes,
You're doing that.
that is such a slippery slope. And when you start getting down to the questions that buyers who are not represented always ask when they're touring a home, right? And that's where I see agents stepping over the line all the time. But I think that's always been an issue. And maybe with this coming out, it helped crystallize where that, advice and opinion is. And it's not a very hard line to cross. But in verifying information and trying to promote the house, most of that can be, within not advice or opinions, but,
I mean,
and what the seller wants. Put this much earnest money they want, this much, option fee. You
yeah,
can say that, but
you can do that.
I wanna-
after Brian.
There's another little slippery slope that I
Hold on,
want to,
Let Brian finish. And then-
No,
I'm sorry.
there is the provision that says you may confirm information to a party regarding the size, price, and terms of the real property available for sale at least.
but you're talking about only
But-
in this new
Yeah, I'm.
thing. But if you're a listing agent, that's not in that section. That's old school, the way you have always been able to operate.
Yeah, and as I go there, that's also too to what unlicensed people can confirm when they call into a real estate office, right? It is square footage. We had the similar statute on unlicensed activity, which is not advice or opinions, confirming pre-advertised details, basically, of that.
I want to, on the record, also say that this committee right now in this discussion is getting into a little bit of a slippery slope. And anybody listening out there, the opinions expressed by the attorneys are their own. And this committee is not the education committee. And we are not, the mothership,
Mhm.
track, and we
Judge and jury,
don't, and
definitely
we
not.
do not, this committee does not give advice on how to handle a transaction to anybody. So this is just a discussion and an interesting conversation between us because this is a new bill, but do not take anything that any of us say as legal advice or other advice. And then the next thing I want to say, and not criticizing at all that it wasn't in here, but the bill analysis, anybody can look up legislation. even before it becomes part of the actual laws and codes. And not only is as Ron had up on the screen, the new language built into a bill or the brand new language that's creating, whatever section of the bill is available, but there's also a statement of intent, which used to be the legislative history in it. And the legislature tells you why they're doing what they're doing. And in this case, it actually starts with, in 2023, a class action lawsuit brought against the National Association of Realtors and several large real estate brokerages highlighted an opportunity for increased transparency between real estate brokers and prospective buyers. This bill seeks to elucidate the real estate transaction process through three main provisions. And it talks about the three main provisions and why the language that it's put out there is there. Whether it's perfect language or not, they explain why they're trying to do it. So that's always handy for somebody to look at, including this committee and then anybody else.
And this one in particular is particularly well written in terms of the intent. Sometimes they can
Yeah,
get confusing. This
is
one's in
big.
pretty plain language in terms of what their intent was. And I agree that that's a great resource to follow.
Probably TXR.
That's a,
Might have, there may have been lobbyists involved in helping.
so let's circling back, and this discussion is a good time, and also it takes out some of what I was going to go into anyways when I talk about the buyer representation agreement. But going back to the format at hand, or the broker information at hand here, and I'm circling back to you, Lee, because I forgot where we left off with your original comments.
Well, I've processed this now, and the elimination of sub-agency, which again I'm a fan of, also eliminated a consumer choice, but
Well,
that will come out in the future. This page, can you explain this to me?
So a couple things here is not understanding other broker is one of the things of who the other broker is. And can we simplify that by saying, do we mean the buyer's broker and the seller's broker? Or, here that I think there's a lot of confusion on what the selling broker means, right? Is that the buyer's broker or the seller's broker? There's a lot of confusion on that term. So can we simplify to more plain language and general common understanding by just saying buyer and seller?
Yeah.
And then
Like
remove
buyer,
sub-agency.
seller broker.
yes, I knew that.
I'm on board with that, yes. Second,
And so,
let's do that.
okay, everybody agree on that?
Make it
So
simple.
So that's what it means on further down when it says buyer or seller. You want the same thing. I was looking at it on the same line and I'm like, nah.
Intended for conversation,
Yeah.
not as.
It makes sense if you
Yeah.
know it.
Now it makes sense.
Yep.
Yep, that works for me.
I agree.
So, and so now we no longer, well,
Now,
on the
then I,
buyer broker side, we don't need the represents thing.
then as second motion, I would move to strike the sub-agent box here.
But do we still need buyer only as buyer's agent?
Well, what you do is you say represents buyer as buyer's agent. And no checkbox.
Can I
because
make
we have
a
intermediary
suggestion?
on the
Okay,
side.
so take out the checkbook.
Can I make a suggestion? Since Ron is he's made two motions that nobody's second. How about
I'll
you
second
put
it.
it the way, put it up on the screen the way you want it, so we can all see it,
Okay. Well,
and then I'll second it.
sure. It wasn't,
Yeah, because I don't
We have enough
need
more
those
motions
boxes
yet.
because
If
we
we
have to
can
go
do
through
this.
an
If you
offer.
take the boxes out.
We have to have a buyer's agreement.
so what I would.
Should
do-
have a
There's
buyer's.
some,
According to law.
yeah, before contract. I would argue there's a little sliver of an exception.
Yeah.
Let me go back.
I would just say buyer's broker, seller's broker. I
That's
think we still need intermediary, but I don't think we need the rest of them.
So what I'm recommending is that we refer to change other broker to buyer broker.
Right?
Okay. And
On the left
Yes.
of the
Mhm.
form.
Listing broker to seller broker.
So that's
Seller-
buyer broker.
seller broker.
I'm gonna write on my form. This is my form. Okay. Instead of other, it's gonna be buyer. Broker. And then we're gonna leave the boxes below or no?
Well, that's what he's writing, right?
Let Ron,
Yes. I asked for that. I should be quiet.
Strike through that.
get ahead of his keyboard skills here.
So you just eliminate the choice for that second choice, seller as listing broker, sub-agent.
Right, but the question is, why would you have the first one? If we go in with if we have to have a rep agreement at offer, I'm just asking a question.
Well, I mean, I guess you don't have to. I think if it's, since you're disclosing agency, I think it's helpful to say represents buyer.
Okay.
Yeah,
Mm-hmm.
without the checkbox. Just make it a sentence, represents buyer only as buyer's agent.
Right.
Oh, without checkbox. Okay,
Right.
got it.
I'll be a little more precise here when I write up the minutes on this one. We basically refer to.
And then
the-
you're also listing on the right-hand side, take that out. From
No.
listing to seller.
Oh, do you want to strike,
Yes.
change the word listing broker
I believe
to
that's
seller
what,
broker?
broker.
It's interesting how it's been inconsistent
Yes, leave the check spot.
for years and nobody ever seemed to notice. I never noticed it until I looked at this, where we had listing and seller, where it should just be seller every place where halfway down on the intermediary side.
But we're gonna leave
Is there
the boxes.
listing broker
On
or
the
buyer broker used throughout the contract forms in other places?
Part of your motion that I seconded was to make it consistent throughout everything, right?
Like, right,
Yeah.
it should be the same. Right. So actually,
So there is a reference in the attorney's fees paragraph, which is
17. So,
That's the only, in page 10, but we're moving page 10. At the bottom. Is it at the bottom? Yep.
To see that.
But that's gone. That's the only two places I saw this one.
I'm glad the bottom's gonna be gone. I am.
Only, I mean, not in the farm and ranch,
Gone before.
right?
Yeah,
Yeah.
Yeah, we left it, and actually,
we're leaving, so.
it was a year ago
Come back
this month
for that.
that we had voted to actually retain it, and I pulled out the wrong minutes when I was starting to prepare here, and I was like, wait a minute, we voted the other way last meeting. And it took me 15 minutes before I realized I was looking at the wrong piece of paper.
Right.
Under paragraph 17 of the contract, it says attorney's fee, a buyer, seller, listing broker, other broker, or escrow
yeah,
agent.
just said that.
change. Yeah, we'll make that change. So this will be done throughout the contract forms then.
Well-
Ratification of fee.
Yeah, okay. So it is on, and we are keeping that, the broker information on,
Right. It'll look
so
the
it's
same.
there.
Now, you want me to throw a loop at you here for fun?
Let's do it.
I'll do it. I'll do it.
Can't
Okay.
wait.
When you're an intermediary, you've got the seller broker at the top, and then the section at the bottom currently says selling associate's name.
Yeah, we'll have to
Do we
change.
want to
Buyers.
make that say buyers?
Maybe seller.
It'd be buyer.
It'd be buyer.
Be a buyer there.
Buyers.
That's where that
Buyer.
confusing term is.
Right. So we need to make sure to clarify that in there.
Maybe it ought to
It should become
say
buyer
intermediary.
Well, yeah, so the word
No, but the intermediary is
The
the
words-
broker.
Is a broker.
And this
selling,
is wanting to name
Right,
the
right, right.
agent for both
Yes,
sides.
Right.
should we just strike the word selling on those three spots down below?
Yeah,
But it needs to say who
And
that,
change
that's
to
the buyer.
buyer.
Buyer, yeah.
buyer associate.
Yeah.
Because
I
this
think
is,
buyer
this
associate
agent is
works.
gonna be the seller's associate, and this agent's gonna be the buyer's associate inside the intermediary.
Maybe we say assigned, that
appointed, doesn't.
appointed, yeah, appointed, not assigned. Appointed
Appointed, right?
buyer associate, appointed seller associate. I think that makes, it distinguishes it from just,
How are you gonna
Yep.
do that if it's not intermediary
That's
and you're
problem.
using the top portion for a
Yeah,
regular
thinking about
transaction
even
with a
listing.
buyer side and seller side?
Well, I think it just makes sense to selling
Yeah,
it
associate's
has
name
listing
because it-
associate up
what-
there.
Well,
Yeah.
in the intermediary case,
well, what's wrong with having seller
No.
associate and buyer associate?
well, you're
Yeah,
gonna
I
have
don't see
sellers.
Keep it simple.
So you have represent seller and buyer as intermediary,
Right.
and then you're gonna have associate's name without
sellers.
the word listing there, or you're gonna put sellers.
Seller.
Yeah, seller.
Sellers
It was
broker.
only highlighted.
Seller associate's name.
Seller
You're gonna put-
associate.
No, but I mean, are you gonna put seller's associate,
Uh-huh.
a seller's broker's associate, or are you gonna put sellers,
Seller's
list intermediaries?
I think you need to put appointed.
You know what I'm saying?
Which,
You can't put appointed because you
Wouldn't
can
it be the
still
same
have
thing in
intermediary
either
without
case?
appointments.
Okay, but you're saying seller's broker, right?
That's
And-
the top one, right?
Right, okay, so let's assume that we changed listing broker, seller's broker.
Okay.
All right, then I check the box, seller and buyer as intermediary.
Okay.
Okay, then I come down here, I say seller, broker's, associate's name. Is it seller's broker or is it the intermediary broker?
I think you say seller and then buyer agent.
So what I'm saying is, it seems to me we're not using the common term when we're in the intermediary situation there, or the preferred term.
I have a thought.
So is it an old-
So maybe we leave it saying listing broker. That's fine. But right underneath it, it says represents the seller and the buyer as an intermediary. So it makes sense that it would be seller's associate and buyer's associate because it already specifies we're doing both.
It's
We got
not,
both.
it's not seller's associate, it's seller's broker's associate.
I see what you're saying.
Correct.
What
Okay,
if we-
so it's not, it's a
so is
a nuance, it's a nuance there that I just got that you said, yep.
Right. And so if I'm an intermediary, well, I'm not just the seller's broker.
right.
That's all I'm saying. I'm trying to reflect the common usage of the terminology without, and maybe it's not even worth the discussion. We just make.
I think with,
Now, what we could do is we could put seller's broker's firm up here and represents there, and then just strike everything else down below where you just say associate's name.
You need to be
and
clear which associate we're
broker's
talking
office.
about because there's
Yeah.
there's potentially going to be two.
Well, I know, but they're listed underneath there.
You know,
Doesn't matter which one you list.
let me
first.
just throw something else in there. The only place that associate is used in the whole contract is on this form. It is not part of the contract. It's very weird. It's not, and we've got it capitalized, so it's a defined term or alleged defined term, and it's not a defined term. But in Trella, in the associated license holder acting as an intermediary, it uses the words associated. So that's where that came from.
So what I'm recommending here
Well-
is if you wanted to,
But it's not capitalized.
what I'm
I think. Ron, and then I'm not sure, I didn't see who got first.
Go first.
So if you just come here and do this, just strike this, and if you want to change this to seller's broker's firm, that's fine.
Yes.
Right, or seller broker, or I'm sorry, firm, then you just strike this all the way down here, and you don't need selling associate or listing associate. You just say associate's name, and it's listed on the right-hand side. So I think it's going to be pretty obvious that you're going to get the two brokers on the listing broker's side here, right?
The two agents,
Yeah, the two,
Or whatever.
the two agents.
associates,
That's
actually.
all I'm suggesting here.
But how do you know which is which if you don't put buyer and
doesn't
seller?
matter.
Well,
Doesn't
it does matter.
That's
No,
how
not
it
for this.
matters. Then
Sure
you
it
know who to
matters.
Communicate with
Fine,
for which party's
as
stuff.
That does.
Matters in big matters.
Yeah.
I think it's important to put it on there.
Oh, you were first.
Okay, so
Yeah, let's see, Lee.
Yeah, so I get exactly what Ron is saying about it's actually the seller's broker's associate instead of
Mhm.
sell.
Mhm.
I still think that, I mean, it's not, this is after the signature, it's not part of the contract. And I think if we just say seller agent, buyer agent under intermediary, it's going to be more well understood
I agree.
because it tells them who's working with
Each side.
which party. So that, but then I almost hate to say this out loud because I can hear the groans coming, but it's not always going to be that there was a listing and now it's happening in-house. We could have a buyer broker agreement and we go out and find a seller for that buyer and there is no listing broker. I mean, this can go both ways.
1%.
So we're kind of,
Mhm.
why it's a growing percentage. I
You're braver than I am. I had that thought and didn't want to say that.
I mean, we're,
She's leaving.
we,
Say it.
that's right. I'm the lame duck, but we've got to start treating buyers and sellers equally and equitably. not done that for a long, long time, and
Not
here
true.
we sit. Yes, true. Yes, true. We
And my concern with using associate potentially is that there's a discussion from Trek as a whole
Mhm.
about looking at broker associate.
yes.
And that's in
Yeah.
And so if we-
1968 too. That's changed a little
Right.
bit to provide some clarity.
And so if we say associate, now we're like buyers, and then associate broker, associate agent, like, I like using agent.
Well,
I don't know.
but again, the language associated license holder acting as an intermediary, it doesn't actually say listing associate or selling associate or buyer associate. It says a license holder associated with the broker to communicate, carry out
Mhm.
instructions of one party of the transaction, and the other, but another associated with the broker. It doesn't actually say associated, but it says associated instead of associate. And that actually,
Yeah, I'm not going down on this sword.
Yeah.
and it does,
I'm trying to think of
is
what
that
solution it
changing
would be.
560? Let me go back to my,
Well, if you wanted to do, one thing you could do, you could do something like, if I can get this thing is in my way.
I think it's something that satisfies your concern after a while.
Yeah. Let me see. What I was thinking is if you just went in here and just added something like,
Just so you know.
just adding something like this, some reference to the seller here and doing the same down here with some reference to the buyer.
Okay.
I think you need to do that.
Fine with that.
I mean, I don't know if,
So
I
just
don't know
say
if that's the right thing.
associate's name. Yeah.
So maybe I'm oversimplifying this, but
Oh, please.
if you've got,
Please do.
if you've got the left-hand side,
What did I do?
you took it away.
I'm sorry.
That's okay. We've got our piece of paper. If you've got the left-hand side that we are redefining as buyer broker, and then you've got associate, the blanks and stuff for those associate, and you don't add, in other words, I guess if the left-hand side is buyer and the right-hand side is seller, which includes when seller acts as an intermediary, if that box is checked, why do you need?
Buyer wouldn't,
I-
the
I'm
left-hand
going
side.
down the same
wouldn't
road,
fill that
but
out.
Just because
they
they're
want to know
used to it.
which associate is working with the seller and which
Let me-
associate is working with the buyer.
Let me blow this up real quick. Blow up what we had
within
before.
the
Yeah.
Selling list.
Yeah.
Okay.
Intermediary.
Thank you.
What if we just had it simple of the top part and then a separate box underneath saying if an intermediary transaction, and I don't have the exact language here, blank is appointed to represent, have a whole
Because they're
separate
not
intermediary,
always appointments. You can still have
Oh, without
intermediary
appointments.
without appointments.
or you can have a box saying there are no appointments. It just having kind of
Okay.
break apart the intermediary from this, just as a thought of not being stuck with what we have, trying to monkey with it as another whole idea of having
Well,
those in a whole separate intermediary
That
thing.
notification of-
Then with that, what about the checkbox? You're saying seller and buyer as an intermediary. Is there another checkbox that's required appointments or no appointments? I'm just asking, to verify, because if there's no appointments, you're only filling up the top. If there's appointments, you're filling up the top and the bottom, and the bottom should look just like the other side.
No.
And
Diane?
buyer's agent and his buyer's address and stuff.
Can we eliminate on the now intermediary side, the buyer associate's name and information and put another box under the buyer side to say that it's an intermediary transaction so that the buyer information, there's only two boxes. This is buyer side, this is seller side. This is buyer representing, agent representing buyer, agent representing seller, and the box underneath there saying that this is an intermediary transaction.
That's kind of where my thoughts were going. I haven't been able to flush them out here, but it kind of breaking off intermediary to where it's not just subsumed within this other information somehow.
Not always. It's oftentimes misused, and agents put them on those two sides and not understand that it's supposed to be intermediary. Yes, because they don't read, I understand. But just a thought.
Well, let me tee this up and then come to SJ is, do we make a simple change today, buyer to seller, knowing it's not perfect? It's not perfect now. It's not going to be perfect in the future. We have to do something with sub agent, right? And then look at this further as one of the subcommittees to look at, to present a box. I do think this needs to be thought out. It's been a long time since we've done it, and with the intermediary issues, I don't think we're going to be able to arrive at something today, but it definitely
Maybe.
looks at. I'm willing some more time, but I'm just suggesting it where this looks like it's. To me, I don't want to rush to do something, but at the same time,
And we
change.
have an obligation.
Hybrid, what you said.
My hands up.
Oh, yeah. Oh, that's right. SJ was
Yes,
next. And then,
absolutely.
Okay, one thing, the legislature's told us to do something, so we have to do it. I don't think you get to kick the can down the road.
I'm not doing that. I'm making the change that's required and a simple other change to then more think out other
All right,
things.
following what you guys were saying about using the buyer box and the seller box and then just checking below, is it intermediary? My thought is that you actually have two sets. So maybe at the top, it's a plain Jane, I have one set of brokers, and agents on the buyer side and one on the seller side. And that's for the regular transaction. And then a line or something in a whole nother setup. That to me is less confusing. If it's an intermediary, use this. If it's not an,
Yeah.
intermediate, use
That
that.
sounds good.
That's much more,
Mhm.
I have,
That's where my mind was going as well, something like that.
sounds good.
although it makes it a little longer.
I would
That's
recommend,
good.
given the time frame that we have here, that we leave the listing broker firm, that term, leave everything on the right-hand side the same, because it works. Because if the listing broker, it's a true statement to say in an intermediary, that's the listing broker's firm. And then you leave everything else down here, and call them the selling associate, call them the listing associate. It's not a defined term in the contract, except as used in the, in that paragraph 17. That's it. So I would say leave it alone. It's a simple fix. We can go into more deeper issues here later.
Are you gonna leave it capitalized, associate? Because
I'm
that's
just gonna
not,
leave it on the right-hand side, everything the way it is. Take all these strikes off.
And it's a signature line where I think it makes sense to have things capitalized that aren't defined, when you have it underneath the.
I don't know, that's.
So make this change about buyer broker over here, okay? That we're talking about making over here.
Instead of other, you're gonna
Yeah,
have buyer.
This will be other.
And getting rid of
This will
the
be buyer and
the second box.
Right, and that's
I mean,
the,
the sub-agency.
that's the only thing that I'm talking about. We'll do nothing on the right-hand side.
Yeah, I think this would be perfect time to have consistency on the
Correct.
right-hand side.
Correct.
Because
Yeah.
we're mentioning buyer and seller in the boxes,
Yeah.
and then we're using listing. That's why I highlighted all those. Listing and selling were inconsistent. I think this is the perfect time to be consistent and clarify seller broker firm,
Talking about here.
buyer broker firm, or buyer associates on the bottom portion. I like, and we can't do it now, it would sound like, but I like SJ's idea and having it separate. I think it's going to be easier for everybody to understand, but I would not pass this opportunity up of consistency of seller broker firm and buyer associate and the right-hand side.
There is no reason we can't do it now, other than a self-imposed, somebody wants to leave at noon. Okay, there's no reason
No,
that we can't.
There's not what we're saying there, but Lee, go ahead.
So I really, I mean, like SJ said, we've got a mandate. We got to make some changes here. We need to get them to the commission. I think exactly what Ron was saying. Go ahead and change the left side, because there's no way that has to change. The right side is not ideal, but it still works. We leave it, get the minimum done, and then you work on exactly what y'all were saying, split it. And when you put that second section that hits intermediary, make sure you don't limit it to the listing broker being the intermediary. Get it right.
Agree.
Would Melissa was next.
I would rather do it now.
I
And-
agree.
and
I
here-
agree.
And here's why, because I think you make a change, and then you're gonna make another change, and just do it. But we are gonna get rid of this whole disclosure part on the bottom. We've got,
There's room.
we got enough room to divide it, and I kind of like the idea of
I
having
like what she said.
buyer seller up here, not intermediary, buyer seller down here is intermediary.
Yeah.
It's super clear, yeah.
I think the brokers are in
That's, so what if what time, do we know?
But I think we do it today.
11:45.
30 minutes.
So what if we move on to the other business that we have, if this is where we're at, and then over lunch because drafting by committee here to get this done, I almost would like, some one or two people to sit down and punch something out.
Yeah.
That then we can look at it on the screen instead of trying to come up with it together and wait while that person drafts it.
But can we agree before that break, what we're going to do about capitalizing and not capitalizing? I mean, we just went through this whole discussion of defined terms and not defined terms. And whether we like it or not, that we capitalize things when somebody signs, this isn't actually signatures. It's not signatures. So that actually,
That is.
so,
lines.
my suggestion is we follow our own convention. It is capitalized. The word name is capitalized on here, making like everything is capitalized. But I don't know. Let's just agree before we take the break so that we don't have to have the drama again.
Well, I'm gonna put myself out there to say, I do not care if I think they're fine capitalized. I don't think it's inferring any kind of meaning. It's just like the title of a document.
Okay,
That would be the way I would look.
all right. So the drafter, Ron, can decide if he likes it capitalized.
Giving you hope.
Okay to do that. I think that's a good idea, John, to
If we're
make
gonna do it
Ron.
today- If
Ron
we're gonna
it.
do
I
it
think we need
today,
to do
I
it today.
agree.
Okay.
Did we hit everything in the new bill that needs to be changed?
That needs to be changed that we will do, right? And then we need to have a discussion. Well, no, IBS, right? We don't do the IBS, right?
Yeah,
That's a
okay,
required change for
right.
that.
Leadership at Trek changes. Uh-huh.
And so that's separate that we'll have to change with the, taking out the sub-agent language from the IBS and then adding an additional disclosure about the non-representation status, what that means. It's interesting because the statute does not say exactly what needs to be in that notice. It just has to describe the ways in which representation can be done, or non-representation, I should say.
And available by January coming from Trek.
It must by statute. They will have to have that.
But not us.
Not
This
us.
committee,
Not
not
us.
this committee.
So
But have we hit everything that this committee has to hit to comply with the new statute?
yes.
Great.
And then that leaves open the buyer broker buyer representation agreement. We're not required to do it, but leaves that open. Just make that clear. But other than that, no, there's nothing else.
And just to clarify, all bills are effective September 1 unless it's a different date. And this one doesn't have a different date?
It does. January 1st.
January 1st. Okay.
January 1st, 2026.
So we will, when we push this forward now to the commission, and if the commission likes what we did and they go forward, then everything has been done before the effective date.
Correct.
And we have enough time
Yeah, so that's another one.
to comment and all of that.
Which was a big reason for this meeting, right? So we can get out to do that, or if we wanted to take further steps to get it ahead of the deadline or meet the deadline, I should say.
To your statement about the buyer broker representation, that is there any thought or direction on where that would come from? Is it expected that the individual brokers and their companies would do that? Or is that something that Trek is considering?
So that's on our table to discuss, right? And right now, the available forms through the associations do not satisfy the new requirements. They have already, the associations have put on webinars. They have their own form meetings that I know their forms will change. And what we have now is a specific language that must be addressed in those representation forms, and specifically for the new non-representation status. And in fact, it says the statute, if you enter into a non-representation agreement to open up a door, it can only be up to 14 days long, and there's non-exclusive. And so there's some specific bullet points in there. And if you then change to represent to do any other brokerage activity, other than opening up the door or touring the homes, but we're loosely using opening up the door here. Then you have to enter into a separate written agreement for that expanded representation. And so there will be, by necessity in the statute, I believe, 2 different required agreements if you're first doing I'm only opening up the door. With that, I believe the associations know that they're developing their forms. I believe they have a meeting next week that's going forward. I'm confident they will have a form available for use by their members, right? And then second to that is, well, what about the non-members? What about all the license holders that are not? And this was at the last meeting when I raised my general concern about our brokers that aren't members of the association going to be pulling forms offline. And what are they, I was really concerned about consumer protection and how can we develop it. And I spent probably 3 days drafting and figuring out and going through. I went through every rule, it's chapter 1101 of the Texas Administrative Code, which is TRILA, every statute to pull out anything that would touch on a buyer broker's obligations to see how can we, because we historically, as this committee, have never drafted a representation agreement, whether that be listing, whether that be for the buyer. And it would be an extraordinary step for us to take to develop one of those. And it's tricky because it's unlike protecting the consumer in terms of a transaction itself. Now we're getting into private business deals between license holders and the consumers. And that's not necessarily a reason not to do it. In fact, the statutes contemplate certain things that if on the listing side, if this committee would ever promulgate or the commission would ever promulgate a listing agreement, there's a provision in TRILA that says it has to do this or it can't do that. And so the rules at some point have contemplated that in the past, which then now to extension of the situation we're at, because of the past history that we haven't experienced an issue with the buyer representation agreement causing friction or lack thereof, I should say, causing a problem, right? The brokers that are not members of the association have been getting along for a long time without having a form to use from us.
Right.
And going through there, my position has softened on the absolute need to have one. Do I think it's best for there to be helpful forms out there? Yeah, absolutely. And at the same time, brokers are in a business, right? They are required to be competent. Their fiduciary duties. They have a lot of requirements of them. And if they do not want to engage their own legal counsel to draft one, they have the availability to be a member of the association and get the forms. They can pay their own counsel to do it. Buyers could bring their own forms, right? And so to get over this hump that we have right now of not having one, never had one in the past. And my biggest concern that I was on the other side of the fence at the last meeting of we really need to look at it was the fact that, well, they're going to pull it offline and stuff. But to me, it hasn't presented itself as a problem in the past history. So I'm not comfortable yet in taking that additional step. That said, I have a form I'm not prepared to present today after going through all this that sets it out in different ways. That I try not to be burdened by the association forms and drafting it. And I threw all that out the window of anything at the earned and payable, all that stuff that has been historical concepts. One of the biggest shocking things to me in there is how the compensation is effectively said only if you close, right? The option, and this all may be changed, but it's only if you close. So, or all these different things that I mean, go through the list of it. And how do we not comment as a committee or as a commission on steering the business, to a particular way that will impact practitioners and consumers alike? I welcome anybody to join me on the subcommittee to further look at this and see what I did. And what I really set out, just to give you the outline view of starting with just, identify the parties, going with the term, and then what are the broker's obligations? What is the broker actually doing? And set them out and using the statutory language that we have combined with how that's interpreted through our rules and our contracts, right? In making sure that it was consistent with what's in our contracts. And it ended up being, I think, 8 points under the broker's thing. The whole thing's a page and a half. And if you add in the other notices, it maybe adds another page and a half to it. But then after that, going into the buyer's obligations. And there's 4 points on that one. And one of those is broken down to the compensation. And the compensation, if we try not to put our finger on the scale so everybody can think of this as, oh, you can be paid a flat fee right up front. That'll do XYZ for you. You can be paid a flat fee that's paid at the end of the term. Or you can be paid a flat fee or a percentage when any property closes that and property changes hands, or the earned and payable thing, which I didn't use. I used other, I think, more plain language that simplifies it. And that way, that has a whole spectrum. And then another others box. So there's 4: flat fee at beginning, flat fee at the end, paid at closing, whether it's flat or percentage, or another. And that, to me, it's on the fence. That kind of opens up all the business things. So that mitigates my business steering concern. Mm-hmm. And then after that, we get into the mandatory notices. And I have probably, I think it's about 10 mandatory notices in there, whether it's by statute or things that I thought are helpful right out of the statute, like agents can't practice law. They can't draft a contract for you. They can't do this. And in doing that, Ron and I briefly talked about this. I think there's some language that we need to clean up in the TREC rules. In the statutes, in the statute, so TREC can't do anything about it. The legislature changes it. But right now, 53711, which says that you have to use those standard forms, has exceptions. One of those exceptions is for transactions for which a contract form has been prepared by the property owner or prepared by an attorney for the property owner. That's not expansive. Now, we all understand that, generally that includes buyers, buyers' attorneys, but it's drafted in terms of a property owner. So there's other things that I think need to be cleaned up now that we have this new lens and context. But I think we can get there. I think we can get there. We can look at further developing this form, and I really try to take it from a different angle, not looking at what's been the standards and customary, all those words that lawyers are throwing around in these lawsuits. So that has been used more commonly than anything else in the transactions. And so I welcome anybody that wants to come help further develop that on there. And I have a pretty good draft. I'm just not prepared to present it today because it will not be ready for the publication time for the before January 1st. And nor am I'm on the other side of the fence of where everybody else was, I think, at the last meeting of, do we really need it? And I'm kind of over the side of it. Right now, we don't really need it. That's a good form that maybe somebody might want to, hire an attorney to go draft or something like that. But do we need to do it as a committee, or do we need to have it as the association might come out with a very similar, changes that are perfectly good, that everybody starts looking at that language.
I would just add to what John has to say is whatever committee works on this, and this, again, this committee needs to be aware the legislature has just spoken on this issue. And the third, it actually says this is their third explanation of why they passed SB 1968. Says SB 1968 requires a license holder who performs any act of real estate brokerage to enter into a written agreement with a buyer prior to showing any residential property, or, if no property will be shown to the buyer, prior to making any offer to purchase the property on behalf of the buyer, period. The written agreement mandated by this bill is not a buyer representation agreement, but can be if the broker and client so choose. Its purpose is to provide transparency to the buyer regarding the relationship with the agent and the costs they expect to incur during the course of the transaction. I suggest, again, strongly that everybody go and read the statute and read the sponsor statement of intent, as you're mulling what to do. And at the end of that, I agree that it's not something that needs to happen now by this committee.
I'm in agreement with that as well.
Yeah. The associations have already started editing all their forms.
And I'm concerned with the you're not relying upon that. That's not factoring my decision, because I think we have a sizable chunk that's not a member that is now has to. In the past, they could just say, I'm just going to roll the dice and hope I get a commission. Yeah.
So, I mean, that's
but that's
just an
changing.
observation. Business is changing because of this, all of this. You know, and brokers who are not members of an association or are members of an association are having to deal with these changes. That's just part of it. You know, and again, they get a license because they're allowed, although they're not allowed to practice law, they literally are allowed to practice law in a very small box. So that's
I guess that's a concern with, it's not the brokers that are attached to an association. It's the brokers out there that are not
there's
attached.
plenty of people with an association that aren't paying attention.
Well,
Like
but
they
it's
should.
available. I'm saying, but a broker that isn't attached to an association, you know, I guess they go out and, you know, get a lawyer and draw up their own, but then that's a lot of different terminology out there. I mean, I'm not in an area that we're not with an association, so it doesn't affect me. I'm talking about, you know,
Well, and I'm
what
gonna,
other areas would it affect? Yeah.
from a business owner perspective, large business, small business, you choose to get a license, you choose to operate a brokerage, you make business decisions, you hire legal counsel, you know what laws you operate under, but I don't want to be bound. I want to have choices to create whatever I want to negotiate with my client, with my brokerage and the services we offer and the terms we negotiate under. And I don't necessarily want to be bound by specifics. We don't use Texas Realtors forms for buyer agreements at all. We have our own attorney drafted forms that we use on all of that. And I want to retain that opportunity as a business.
Well, that was the whole purpose
Yeah.
of the lawsuit, is to have transparency in the negotiations between the buyer and these licensees and seller and the licensees. So,
And I would say the thought that I had of doing one for Trek was, the thought always was voluntary use. There was never a thought, even though when I was on the other side of the fence, of doing one that would be mandatory, because that absolutely, I don't think we want to direct the business dealings. It was the concern of what are brokers actually going to use at the end. Any other thoughts on that before we?
I would love it to be involved because I don't know. I like the protection of the buyer. So I think if I'm even a small brokerage and don't have other forms, it'd be better to have something that's not voluntary, but I mean, it's out there. Or do I have to go set something up? I just think we're missing. I mean, maybe that's a 5% rule. I don't know how many are not attached to associations.
Did I see your hand raised too, Diane?
To help you, yes.
Okay.
I have a comment. I don't want to help.
you've already done me on all.
Hey, I got hey, this is better than last time. I was in my own head a lot between the last two meetings.
So to SJ's point, the legislature has spoken and said this is the thing, right? But I just want to make sure that I'm clear. That doesn't mean that we have to come up with something. That just means that if a license holder has a license and isn't following the statute, then they're subject to disciplinary action. Am I
So
right?
this goes a
Like if
little,
I choose not to do a buyer representation agreement, or I choose not to follow what the legislator said, whether we have a form or not, whether they're part of the trade association or not.
You go to real estate jail.
Yeah, you go to real estate
Yeah.
jail. I like that. You're subject to disciplinary action, right? So I don't know that I feel like that's a requirement and a mandate on us to make that.
You're saying it's not an instruction to this group.
Correct.
Yeah.
Yeah. It's an instruction to the license holders that they have to do something, but not to this group to create a way for them to do that.
So
I don't know, maybe
It's
I'm wrong.
fair-ish.
I would say fair, but the qualification I have in my head is I can think of ways that this will impact. I mean, one thing that hasn't changed, right? To collect a commission, you have to have an agreement with your buyer, with your seller, right? There's to enforce it, to enforce it.
We'll collect it.
But now if you look at it from a different angle,
Compensation.
compensation, thank you. Yeah, compensation for the services provided. But I can also look at fiduciary issues, right, of disclosures and not providing it, all these other things that would bleed in potentially, that because it's in the actual statute, not just the rules, there might be a little more tied to it than just disciplinary action that will come into other things. I'm not a comment on anything specific, but I can see that maybe being a little bit broader. But I agree with that, Trace. What you say, ish, kind of ish. Ish, yeah.
Well, that's why I was asking, because
Can't
I'm
help
kind of like, is it or not?
It was like what my
we
kiddos would
cannot
say.
help.
If Jeffrey was still here, I'd look over at him about what ish, how far ish goes. Okay, so I want to have anybody else wants to make a comment on that? Anybody online? Nope.
Do we have any more deferred comment?
Let's see. There's contract language. We had a deferred comment on the seller financing addendum. And this is one that it was in regards to the deadline for the first payment and the how the first payment was stated. And I in looking at that to prepare for this meeting, my suggestion was going to be, let's look at that kind of holistically again. We did it in a too distant past, but kind of look at the whole form again in light of the changing situation around financing in general, different rates, and have that thought out, because it's legally correct right now. So it's sometimes being used wrong. And I don't think it's caused a lot of issues to create an emergency action, but I do think the whole form deserves another fresh take. And I don't know if anybody has any further thoughts from our last meeting on that.
Well, I think it's an inherent problem with that form that people who are not professionals think they're JP Morgan, and they come up with all sorts of different payment provisions. The best advice that can be given, and I think we added that to the form, is get professional help, have a lawyer prepare this. And
We did not.
And I don't know
Yes,
how
we
you
did.
can, how you
Bold.
can really change it to prevent them from going off the reservation and coming up with their own payment plans, and create problems.
The one thing that I think the clarification that was requested, we're looking at, is something that lawyers even mess up all the time, and because of the contract. Number of payments issue, and when it hasn't presented itself to everybody when they draft and sign the documents. I say everybody. Generally, what I've seen through my experience is it hasn't really caused a problem on the back end, but at the drafting stage, it's confusing to look at. And so if we can make a slight tweak there to make the drafting easier on the front end, then why not? But at the same time, if we're looking at changing that form, why not just take a step back and look at it again? So that's where I land. Unless somebody has any, I don't think we need to do anything today, is what I'm saying. Any further thoughts on that?
I don't know if you need to do anything ever, but that's not a monkey.
I had a question, John, if I might. While we're on the other side of our agenda is the first page of the unimproved property contract. And while we have people with history knowledge, what is the reason why it says, I was looking through everything for our meeting, why do we say notice under the headline, unimproved property contract notice, not for use for condominium transactions? Why would we have singled out condominium contracts and transactions in no other form, and
Ron?
unimproved
Oh, which one?
property?
I'm sorry, I
Right
was
here.
on the unapproved.
Here we go.
Why do we say not for use for condominium?
Oh, because you can't sell land in condos.
Yeah.
You don't own the dirt underneath the
Right.
condo.
But it wouldn't be
Is that the
unapproved.
reason?
Right.
already-
You're not selling land in a condo. You're just selling air rights.
Right.
So you wouldn't.
Unit.
Yeah.
So was there at some time a need to put that in there for that reason?
When we
Yeah, we just
created the
said-
condo contract.
And Tracy Shores might actually have some insight on.
Address that too. In my local area, we have unimproved property that is condominium that sold boat lots, boat slips that are actually water. And so I could see where that would apply.
Might.
Yeah, there are,
That's
she's
interesting.
correct. There are
Thank you.
condos that look like townhomes, right? So it's not a common interests.
There are
You also,
condos that look like single family residences.
Right.
there are condos that look like bare ground
Mhm.
because they have created a condominium regime it's still
Hadn't been
raw
built.
land, and then they're gonna build later on those individual tracts of land.
So in that case, where
You
the
use a condo
the land
concept.
question would not be able to use this one.
You
No,
would
you
not
use a
do that
condo.
because it's subject
use a
now to the
condo
condominium
contract.
act that has unique disclosure
I didn't know
requirements.
that either,
Well, there's that period of time before it's built,
right?
and you may have a pre-sale.
And while we're on that, attorneys, what is the definition of unimproved property contract? Because this comes up frequently about a slab is on there, utilities are in there, and agents say, and I call the hotline and ask our owners.
My hourly rate is $4.75, and as soon as I get my retainer from you, then we could talk about it. And I have a minimum retainer of, I
Well-
think, $5,000 for this one.
And this is a common issue with across contracts on which one to use, right? On sometimes farm and ranch versus 1 to 4, vacant home versus any of them, condo versus non. So it's a fairly common issue that comes up that we can't necessarily say, here's the straight line. It takes some, and in fact, some situations it might be both could be appropriate.
Well, and then-
more than one could be appropriate in terms of like farm ranch or
Right.
1 to 4.
And then we don't have a commercial form, but it might be, somebody might want to use a commercial form.
And there's a incomplete construction condo form
There
that the
is.
associations have. We only have a condo or the 1 to 4 complete or incomplete construction.
A
So there-
Supreme Court justice once said, I can't define it, but
But I know it when I see it. And
Well,
that wasn't about contracts.
I think the first question is there a lender involved? And then the second question is, what will the lender accept?
I would say the
That's how it happens on the street.
unimproved is not when there's, I mean, the practical, if there's an ag exemption, then somebody is probably using the farm and ranch form. But they also might use a commercial form, which we do not promulgate, that they got from their lawyer, hopefully, or an association. But this is raw land. It's generally,
So
yeah, and maybe it's a brown.
that's the last deferred comment I have, and I plan to maybe continue going until lunch arrives. It should arrive shortly. It's here? Okay.
It's the
Do you
last
want
deferred.
to knock out the comments? And so when we come back, all we're looking at is that in the court case, and then we come back and only look at only 3 comments that we received.
Do it.
Do it.
Okay, so the first one from Wesley Wilson was more of a formatting issue, I believe. He brings up the fact that the system, transaction management system, the electronic document management system used to complete the forms you can't use the standard blanks to jump in to have them formatted properly, like the date field. Some having the year broken off to a separate field versus month, day, year. And wants to see if we can have consistency in the contracts to then flow into these existing systems.
Is that an Abby question? I mean, we don't, this
in-
committee doesn't
In
have any.
like the executed date
Or is it-
inside the box, executed date right above the signatures, it says executed the blank day of blank 20 blank. And that's the effective date. And what happens in the field is people use their DocuSign or whatever it is that they're using, and they throw the month, date, year in the blank for the month.
Yeah.
It's still clear. Everybody understands what it is,
Yeah.
but
Nobody's.
to their point, none of it, nobody ever fills out the something day of whatever month it's very rare.
What I think is.
didn't make it right.
Because like, this is the first time we've heard that this is an issue with transaction management platforms.
Mhm.
But what's new to transaction management platforms is the AI concept.
Mhm.
So if they're having AI fill out their forms,
Mhm.
they do have a problem. I don't really understand how all that works, but I think AI is the difference here, and I don't see any reason to support unlicensed activity by a computer.
I get that. I don't know
Let's
that that's
leave
the
it.
reason. I mean, I just see a lot of times agents don't go in and put a blank and put in the number and then a blank to write out the date. They just don't do it. They just timestamp it.
And I think
Yeah.
the request is here to have one simple blank that's just the date, not the old lawyer language, a blank day, a blank, or however
Well-
it's normally stated, is the.
And also to
is
format it as month, day.
Yeah, interior.
Maybe if there's a
area,
blank,
yeah,
you
so
could-
that nobody does
No,
like
but this is
military and then it's
literally
backward.
asking for that.
Right.
Because the form, the old school legal language has always been executed the blank day of blank month, year. And he's wanting, for one, for us to switch that. So it'd be executed July 11th, 2025, not executed the 11th day of July,
Correct.
2025. And that's one thing he wants.
I just don't think it's necessary.
I don't think it's necessary to
Is there
push.
a legal reason why it should be that way as opposed to other forms just say date underneath?
I don't know that without doing. I mean, the main thing is that a contract is clear. One of the, confusions, I mean, I think you would have to put month, day, year, to put that explanation. Because many people and all Europeans do it opposite
Mhm.
than we do.
Yeah.
They always, and that's where this came from, English common law, whatnot. It's always the day, then the month, then the year, which is not the shorthand of Americans generally. So
In perspective, not being
I don't think it has to be that way.
in
But
my 17, 18 years
clear.
of practice in law, it's commonly written like this in law. I'm not sure where the origins are. That makes sense. To me, the practical side was I can fill in most of the times definitely the year, and I can fill in the month. And
Right,
then
but we
the
don't
only thing
know.
they had to fill
Yeah.
in is the date, and having it right up front to an easy
it's
blank to
usually
fill
by
in.
pen.
Made it by pen, yep.
Yeah.
So it was easy to do and make sure it was done right in the lawyer context.
Correct.
And so I always appreciated it for that reason. Now we're using it obviously in different context here with the new systems and things. So it's a fair point that it's coming up, but I'm not sure we need to take any action at this point.
Right. And just to address his other we actively changed. Previously, it used to say for the year, it used to say 19 blank. And we actively changed it when it, sometime after the century turned, to save time, save,
Okay.
I don't know, but it's not.
And then the legal description here.
Yeah, the legal description scene. Any brokers' thoughts on
I don't think,
legal
I
descriptions?
I don't think that needs.
we can fix this, from the automated fill-in.
They all individually use it.
Right,
And
I think we could fix that.
And I don't see
This committee.
agents in the field having a problem with city of blank, county of blank. That's not an issue.
Type it in.
Yeah.
Well, and for a lot of,
Oh, yeah, I see it blank a lot, but not.
people remember to download the autofill. It autofills anyway, and it works. So,
Out of the-
I realize it doesn't hit everyone.
So maybe the next time it gets a full revamp.
Be
But
careful on
probably not.
autofill.
Yeah, but
Right.
probably not do anything with this now.
So we'll move on to the next one. It's about, can you have a document? It's a request by, is it, how's it about Dahlia Grow? Maybe? Can you make a document that's more than 2 buyers or 2 sellers?
I
And,
think that's a great idea.
Mm.
We've had 3 and 4 people and you have to put them all in yourself.
Oh,
and
No, but I mean, everybody's using the online and you're just having to manipulate.
you're having to
That's-
actually work.
it's, how many do you go, right? I mean,
Yeah, what's the magic number? And that's, and it's formatted.
Right, and it's
It's-
small.
And then we'll do it, if we did it for 3, then they're gonna have comments on this to be
And
5.
if we do it for 8, it's gonna be taking up too much space, because most of the time we only have 1 or 2.
I don't know
Can
that
you make it
we-
smaller?
With the number of transactions we do, we have those happen, but it's not enough.
Rare. It's less than 5%?
and the husband and wife, right? And the buyer, 2 buyers, makes sense to have at least 2. But then past that, it's.
What's that magic number?
I've had a lot lately, so.
Oh, well,
I've had a lot of couple.
I'm just glad you've had a
That's
lot of
good.
buyers.
I say
That's right,
a lot of potential. Snowball be big.
That's,
Um, So this one has come up several times in the past. Bridget, please help me with it about
Bridges.
bridges, but below. I'm so bad with pronouncing names. I apologize for that if you're listening. Why is there no notice of on-site sewer system in the TREC forms? Esther, you want to take this one?
Because the legislature has never told us to put it.
Well, that's a reference to the TAR form.
Yeah.
Right.
Yeah.
So that's why.
And so we do.
How should they do it? Well, write it down and share it.
In the notice that we have regarding sewer and the contracts related to utilities, right? If it's not the notice, that's a separate non-legislative required notice that's provided by the associations. And so that's the reason why, and it occasionally comes up, but that's that one. I guess the other one we had to go over was the language in the contract on with the water disclosure. Last meeting we had this is the last one that we had is what's that?
Right?
What's that? Did we have another one?
Yeah, we got the thing, the stuff that Brian sent.
Oh.
That's the new.
Yes.
Oh, I thought we did that one last time.
Look at it, but it was.
Yeah,
It was a
let me
can of
just,
beans.
let me just summarize. There are proposed FinCEN rules that will come into effect December 1, 2025. If they become final, they're still in a comment stage. People are giving very vociferous comments about it. There are lawsuits challenging the constitutionality of the rule. If the rule goes into effect, it probably would be good for us to put in some provision requiring the seller and the buyer to provide the required information. It is a lot of information that would be required. It's going to cost money to fill out the reports in those cases where the report has to be given. I would anticipate the cost of that will be passed on probably to the buyer because it's a buyer-centric reporting. I don't know that there's anything that we would put into the contract at this time, though, because we don't know that it's going to be adopted.
Just a good FYI.
Yeah.
Something
Okay.
to
So
monitor.
it's coming, but
And it's a good email that's included in the materials that walks through the rule. So if anybody online that's wondering about it, you can look at the broker lawyer committee materials. Starts on page 78.
Question.
Yes.
Before we break for lunch, when we come back, will we be talking about the seller's disclosure notice that's included in our material?
Yeah, that was the other one, that seller's disclosure notice with the contractual paragraph 7H, I believe it was, that's tied to that. There's so that's, I believe, let me look at the agenda, with the page, the broker information page and the seller's disclosure notice / paragraph 7. I believe is the only other thing other than a brief mention of the court case that we have. I do have a received a very late comment that I'll put on the agenda for next meeting, or suggest that we do. But other than that, I believe that's it, unless I'm missing something.
Did we agree we were gonna go and get this done
Yes.
beforehand? Okay.
Yep. So we're going to use the lunchtime to have a draft that we can all look at instead of trying to draft it together as the initial draft. Okay. Well, with that, at 11:52, we will break for lunch. We'll come back at, you want to say 20, 30 minutes? I'm quick.
Yeah.
Record. All right. It's 12:21. We'll call it back to order. When we left on break, we highlighted we had 2 additional agenda items to go through. And Ron's involved with both, so I will let Ron take the lead on which one he wants to tackle first.
Well, let's go ahead and let's take the easier ones first. The earlier you're on the agenda, the longer time you spend. It's like, if you want something done, put it on the last day of part of the agenda. Everyone will be agreeable.
I like that. I like that.
So I think the one of the changes in the all the contract forms in paragraph 7F, which is the triggering paragraph to the water notice that we're going to send up. There is a right paragraph 7F starts off and says that as the surface or groundwater property may be regulated, restricted, or prohibited, including unlimited right to drill, operate wells, right, and goes on. The second sentence there,
Page 6 of the materials, if you want to read along, is
yeah, I should probably put this up. Let me share this here. That would be better than me reading along.
And you're talking about, this is the proposed new edition.
Right. So,
So if you're looking online at the existing form, you're gonna go, what? Like I did when you started reading.
which we voted through last time, and we're coming back to it now to address a particular issue. So this has already been voted on to go.
yeah, this is going forward to the commission. This sentence right here says the parties may use a water notice published by TREC or required by the party to identify information. So what we're suggesting is what I'm suggesting is simply say the parties shall use the water notice published by TREC. And then just strike everything else after that and change may to shall.
Well, I think, Ron, what we said was we're gonna strike or required by the parties and leave in there
Yeah, oh yeah, that's right.
to identify information related to the surface and groundwater
Yeah,
rights.
so change may to shall and strike what I just highlighted there. You're correct.
And he's joined by me for sure from the committee,
And me as well.
subcommittee, whatever we are, working group.
So there's probably, if there is a lawyer that wants to be involved and get additional information other than that, which is hard to imagine what other information you might need. But if you do want to do that, then you can amend the contract or add a provision. The attorney can add a provision, whatever he wants to do, specifying what's there. It doesn't also, you can still use the TREC form, and then you can always, in negotiations, ask for additional information as well.
That makes sense?
I'm agreeable.
Okay. And let's see.
Was that a vote? We need to.
I think we probably need, since we already have it pushed through last time, I think we do need a formal vote. So if we can have a motion to make the,
You made the motion?
Yeah.
Motion, second.
all in favor, say aye.
Aye.
Okay. Okay. Passes.
Okay, and the other one was, what was the other one? It was I think that was it on,
That was it on that. And to going back to the,
go back to that. So what I did here on the, over,
What did he do to his arm?
okay, so
First time I saw him.
what I did here, I've taken a quick stab over at the broker information. Now, this is not formatted, but what I did is I put all the information that's currently in the existing form that I'm suspecting that the brokers will want and the title companies will want. So here, this is the information we'll need if you're acting only as the seller's agent. Here's the information we need if you're acting only as a buyer's agent. And then here is what I thought, if you wanted to do a separate box for intermediary, then we talked about having appointments and not having appointments. I'm not really sure you need this little provision here, but
I think it's handy.
it's handy if you want to go ahead and
So
do that.
if appointments are made, do this,
Right, if no appointments,
then
complete
you can
it.
do that.
Mhm.
Put that where we can see that part. Roll it.
Like that.
One
Lee
more.
would be first. Let's get that on the screen.
Maybe I can make it smaller.
We had quite a conversation about the use of the word associates, and I see it's used there too, so we're speaking.
I think that's the statutory term, right?
Yeah. It
And
is.
Lee,
Well,
hold on one second.
associated.
So I feel like I'm fine with this. However, to the other brokers, do we have concern that license holders are now going to treat this as that written notification of intermediary instead of using the form prior to writing the contract.
So let me ask this question.
I would not.
That question came up.
Okay.
In the existing form where you have the checkbox acting as intermediary, you can make the same argument.
On your listing or your buyer's
No,
agent
on
where
the
you say
current
it
set-
can be
on the
an
current
intermediary.
form. The current
Intermediary
form, the current-
Make the same argument about what?
What you just raised.
Yeah.
Are they gonna
Oh,
use
okay,
it?
okay.
Because they're disclosing at that time that they're an intermediary.
Unfortunately, you cannot control people
But you do
with
the form
contracts.
before you do.
Right. So if you check this box now, under the current form,
Right.
the same argument you just mentioned can be made.
But they could still be doing it.
Yeah, but that doesn't,
It's not quite as obvious to you?
yeah, I guess not. I guess it's just not as obvious
Yeah.
to me. Because I feel like that doesn't make appointments. That doesn't even address appointments. This is very similar language.
It says
And
this
we
here
have a
before.
point because the association had to make, if I recall correctly, correct me if I'm wrong, a change to their forms that said the notice, this does not satisfy the notice. I think it's in the listing agreement, right? Or the buyer, there has to be some separate written agreements.
Yeah,
for
in the,
notice.
the listing agreement and in the buyer rep agreement, there's a checkbox. If you're using the Realtor forms, there's a checkbox that says, do you want or do you not want to do intermediary? Allow it or not? And on the XR form for intermediary, you're right. The very first line says this notice does not satisfy the written consent requirement under Texas law,
But that refers to the listing agreement and the buyer broker agreement,
Mhm.
which do.
which do, correct.
So if you were trying to use that without a listing, that's not a proper.
Correct.
Yeah, I'm just. I mean, I feel like I can stay out of trouble here. I just am a little concerned about my peers trying to use this instead of
Intermediary
the,
notice.
the intermediary notice. And if the brokers don't think that that's a concern, then I'm good. You convince me.
Can we put in parentheses the form number, the notice to intermediary
That's
as
we don't
stated?
have
No,
one.
because it's
No.
It's the TXR.
Oh, because you can't cross over. All right,
but you, I mean, maybe, could we say completion of this section does not satisfy the notification requirement?
I wouldn't want to make that.
Okay, understand.
I'm just trying to see exactly how that disclosure was made because I remember, I believe it's Robin Harris having to, talking about that exact issue. And it was kind of because it was being used improperly. And because it was enough of an issue to require them to do something about it in terms of education and otherwise, which may ultimately be the answer. I just wanted to take a quick second to find whatever they included just to see.
Yeah, absolutely. So the proper way to do it is you do your listing agreement, your buyer rep agreement, your intermediary notice before negotiations begin, and then you confirm it
In the
in the contract.
agreed. Agreed.
So with that in mind, we'll assume we draft the contract form that everyone is complying and conforming,
Okay,
right? That's what I think we should do.
okay. I'm fine with that. And then if they prove us wrong, y'all.
Well, they can always
No,
mess it up.
it's
They can
That
always
is
mess it up.
that is an education problem. That is not a form problem.
Okay.
So the question now would be one of formatting. I don't know if you like, I preferably like this kind of format. Maybe if you want to put some headings with it, that's fine. But
well, if we do it that way, they'll actually see that we made a change there because it will look so different.
Abby does not have a comment about formatting.
Well, and you might could even do boxes around each section, kind of like the earnest money receipt is, and then kind of breaks it out.
That's a great idea.
That's what I was thinking it would have.
I mean, that's what I was saying, buyer, seller, intermediary.
Yeah.
And
Three
and so on,
choices.
you know.
I was trying to save lines because using the columns tends to use up more space. Whereas if you do it this way, you can get more on one page.
While I like the format and I'm looking at this from, once again, this could be an educational piece. It's clear to me what's going to go in blank representing seller, only a seller's agent. How many agents are going to put their own name in there? Are they or not? Am I reading that? And am I just
They need
looking
to
at
say
that?
broker.
So
Does the brokers, and then it
And
says
I know it says the
associate.
brokers are, but they're,
Yeah, you're right.
I'm just, they're going to start putting their personal names in there. I just foresee that. And
You want to put
where-
firm or just broker?
We did have broker firm.
and then license number, while it's clear to me, that would be the broker's license number. How many agents gonna put their license?
Well, that's the firm's broker license number.
Down below, you've got associate license.
I
And
see
you've
that.
got
I
the
just-
supervisor.
You don't need it.
Unfortunately.
No,
No, I think you're good to, no, you're,
That's a good
make
point.
it as clear as possible. Yeah, there's no.
And broker's firm is broad enough to be the individual broker. I was looking at this, but you can see that
That's usually
individual broker.
company is what they're
Well, it's
talking.
how it was before.
Right.
So, yes, I would say so.
I will say broker firm is not a term that we use.
Yeah.
It's just broker.
In the broker information now.
Right, but it's not a term like it's touched you.
Yeah. Do you want to use firm or take it out? That's up to.
Christie wants to use firm.
I would like it
Well-
to stay formatted the way it is and just put these below.
Well, what ends up happening is that because we know that entities, the brokerage has a corporate license number, then we have our broker who has their own license number. The IBS has the actual broker license number. So we need to be clear, is it the firm or is it the broker themselves? So there's a lot of questions that could be raised depending on the terminology we use.
I agree that.
Not everybody has
That or
firm.
not, but
There can be a broker that's just got
Correct.
a human, not
And that,
smart.
and that's
but could
where
do it.
it may not match up perfectly, but it helps avoid that issue, which is
Becky
common.
did it.
Yeah.
Yeah. So,
It's right there.
yeah. So this is not going to have
It
the
doesn't address the appointment
intermediary
issue.
appointment issue though.
Is that the TLR?
No,
I mean,
no.
Texas,
This is,
whatever.
Rebecca here has thrown this out, so she kept the formatting somewhat similar, and then, but it doesn't address the appointment issue. I don't know if the appointment issue.
I think the
Well, do we,
appointment
do
issues.
we need to address the appointment?
Yes,
I think you do,
yes.
if you want to.
The
Well,
whole purpose of this is
You actually-
information, right? This is broker information. So we're trying to provide the information that the title company and other
Information to
people, well, it goes to the title company and it also goes to the parties.
Well, they already know.
there was a time.
Well,
Where else
hold on,
would they know?
one conversation.
Where else would they know?
Okay, Melissa, then Brian.
If keeping the format, if we have, because we've got one person over here, one agent over here, and one agent over here, or one broker over here, and one broker over here. In the intermediary, it's all under the one broker. If they don't have appointments, pick a side, use the left or the right. And if they do have appointments, use both.
No,
No?
no, it's a different.
It's still through the same brokerage.
Hold on, Brian. Accountant
Could
supervisor.
could you make it
They're legally-
simpler by doing the listings of all the associates and their supervisors, et cetera? And then just have a line down at the bottom that says, if it's an intermediary situation and they have appointed agents to represent, then the following seller is represented by blank, buyer is represented by blank.
Well, that was what I was suggesting at the beginning, going back to using the term listing broker and just making the change for buyer broker and not making any changes. But then I heard, no, let's go ahead and bite the bullet and do it now.
That's right.
I would like to call the question and I move that we accept and this proposal that Ron has on the board, and push that forward as our changes and formatted like it is. Can somebody second that?
I'll second
Not
it.
me.
Okay, I know we have further discussion. We have motion pending on the board. And we, further discussion.
Yes.
Absolutely.
Yeah, Lee.
I think the more I think about it, I don't think we need to address appointments. I do think we need a separate section for intermediary so that we're not limiting intermediary to a seller's side. But I don't think we need to address appointments or not.
I agree with Lee.
As we've
So I
written
would
this
say yes
out, yes, as we've written this out and see how this is now looking laid out, I'm not sure that I agree with putting that in there either.
So are you talking about striking this paragraph here, because what we heard before the break was that we wanted one associate identified for the buyer
Mhm.
and one identified for the seller.
Right.
So all we would do here is strike this. Now, in the case where no appointments are made, is this clear enough that I just fill in?
Well, and you take
I
out,
write same or something like
What
that
if I-
down for buyer.
What if we, and throw one different comment on there, because right now we're using kind of the active voice in some of it, or so, of having, if appointments have been made, or, something where it's have been made in a separate written document, or something that, if we wanted to include this language,
I don't think we need to say that at all. I think that sentence where your cursor is, you can delete.
Yeah,
Yes, yes.
and then just leave associate.
okay, I see what you're saying, I like that.
Intermediate. Broker firm representing as intermediary, and then associate for seller, associate for buyer.
And if
And
it's
you're
blank,
done.
there's just no
Yeah.
appointment.
Yeah, I agree.
Strike
I like
this.
that.
I'm amending my motion. Can I amend my motion?
Let's see if you change, is it gonna be along these lines?
Yes.
Or- Okay, so let's let them make changes and we'll,
Amend my motion.
Hold on before you do that. So I think what we were saying, Ron, is then the sentence above that says if appointments were made, that we're
Take that.
taking that off.
Right,
Yes.
And then you've just got the information.
Take
for
this
seller.
correct.
Yes, yes.
Yes, that's what I said.
Now.
Okay, I've amended my motion and at this moment,
okay, that's just gonna.
at this moment, the way it appears on the screen, that is my amended motion to accept this, including the formatting, and push it through to Shrek.
Second,
There
I
you go.
second your.
Okay.
Can get on board.
Brian?
Okay, you can have a situation where you have associates, but there's not been a designation, correct? So what I would say is,
Which is how it was about.
I like what you just did, and then take associate's name, take out the for seller and for buyer, and
No,
then down below, say, if
No.
appointments have been made, blank represents seller,
no,
blank
No.
represents.
no,
You're making it way too
No.
hard. You leave
No,
it the way
'cause it
it
can
is. You may
be
not
not
always have
an
something in
appointment.
the seller and the buyer.
Right.
That's okay.
Fill it in.
So
You won't have
But you're-
anybody?
You're acknowledging there's intermediary.
So if I go in here and I fill out this for seller,
Ron,
then I go in here and I'll just say same. Or Ron, again, I'll repeat it.
Yeah.
You could do that if you wanted to.
Yeah.
If you wanted to. Now, if you bring this other paragraph back up, then that even makes it more clear, but it takes
I
more.
will
I think
say-
it complicates it further.
I will say, this helps with an issue I'm always concerned about is intermediary without appointments. So many agents do it and do it incorrectly, and it should be a very limited circumstance it's ever done in my
You
personal
like that better?
view. So I'd like this better. The only thing I would throw in the mix is, do we want to put the parentheses for seller and for buyer after name, or leave it where it's at in the middle? I don't have a firm feeling either way. Just,
you
um,
have to amend the motion again.
Consistently buyer associate.
That's why I wanted to get it all revised on screen so we can.
Which one do you like it better?
I don't know, it just seems funny in the middle, but I can't really say why.
I don't want to be.
If I would have drafted it, it would have been at the end, but I'm not.
Okay, for the last time, I'm amending my motion to, oh, Abby, yeah, report.
To hear for those online if there's side conversations.
Thank you.
Yes, thank you. All right, I'm gonna amend my motion for the third time for the way it appears now, which the only thing we've done since the last motion was move the paren for seller and paren for buyer behind the associate's name as opposed to associates for buyer name, associates for seller name. And I propose,
Do you want this or not?
mm,
No.
Say no.
no,
Okay.
that was deleted already.
Yes, yes, okay.
You just moved it down.
All right, just making sure.
And I bet Amy's gonna second it again.
Second it again.
And I would also like to call the question, to have the vote. Stop talking about it and vote.
I would like to see what's on the screen though for a second, because I've been,
Top with just buyer.
Let me know if you want to make it smaller or.
what's that again?
I'm just making sure we're consistent up here for seller and buyer, and not for buyer versus just buyer. Between the one where they're independently
Can
represented.
I point one other thing out?
Yep. Brian.
In the existing form, the supervisor, they provide the license number. So
It's at the end of the blank. Yeah.
Oh, I don't have
Oh, we
that
don't
for the
have it.
license number.
Well, because it was on the same, it's on the same line. That's a good catch.
I know we want to vote and move on. I just want
And
to.
they also have the phone number, Brian, along that same line. there's a phone number.
Yeah.
For the associate, there's a phone number for the broker's office address, and there is a license number on there too.
Is there a phone number for the supervisor?
I can't see.
I
No,
don't think it's on the existing
Nope.
form.
It's not on.
it's just got the license number.
It's not on our.
It's got the broker's office address and then phone number. So one would expect the supervisor.
The supervisors, I mean,
The
the
supervisor.
Melissa?
For clarity and training purposes, I really want to keep it with this format.
I
I
agree.
don't want to.
That's not the motion that's on the floor right now.
I'm just giving my rationale of why I'm talking about that.
So in what, I'd like to hear, in what format?
See me.
Is it-
It's the two sides.
Buyer and seller, intermediary, buyer and seller,
Like
as
what-
opposed to buyer, seller, all the way down.
Okay. And right now, this is, and I'm confused, that's why I want to slow down and figure out exactly what we're voting on, because if we vote now, I'm gonna vote no, because I don't understand. And what's on the screen, is this exactly what we're saying is gonna appear? I know it'd be somewhat formatted, but generally just in one line.
Yes.
Yeah.
Yes.
Right, so he's saying with no columns, with the same with columns.
Other reason that you might want to go with this is because it eliminates the term other broker, buyer broker, and seller broker.
Okay.
You're just saying these guys represent who they represent.
So we have the address, we got the team names on there. So,
I will say,
advisor.
Can I ask
Being
why
organized.
address is on every one of those if address is at the top of the page?
Because
That's a property address versus the broker's address.
so I think, Melissa, are you and I on the same? I'm thinking, I'm good with all of the language.
Is the
I also
email
would
address
prefer the
there?
formatting to
Do we
be
have
the
address?
two boxes.
I think
Because it
we
was
need to go
required
to
by
Not
columns.
necessarily columns, but the two separate, I want boxes.
Right.
I want intermediary boxed off.
Okay, Lee, are you okay if it's boxed off at the bottom, like it in the order in which it's presented, just with a box around it?
Could
Do you want a box around each of the items?
Like the receipt page?
Or could we do exactly
Yes.
what Melissa is saying?
Hold on. Kristen, no, Kristen.
I was gonna say, it solves all of it if we box off the third box at the bottom for intermediary and then just keep the one side buyer, the other side seller with the new verbiage, exactly like we have it, and then yes, like we have it written out right. But it doesn't, it just needs to be boxed
We're
off.
not gonna be
the
able
one
to do the
box.
columns, with the information, the way it's laid out like
So
that.
it won't be three separate boxes, just the bottom.
The bottom
intermediary.
box.
So it'd be really two boxes.
Oh, okay.
It's a
Yeah.
box at the top for the two pieces,
Right.
and then the box at the bottom for intermediary.
The advantage of doing that shows it's new as opposed to a fix. By
I don't
doing
know.
it differently,
Maybe that's
formatting at the bottom. I wasn't opposed, I wasn't in favor of it until just now, and I think I'm okay with that.
And
So
it'll call
put,
more
yeah,
attention
there
to
you go.
Yeah.
this
There's a
way.
box. There you go. Beautiful.
And if there's room for the supervisor's phone number, it isn't always the same as the brokerage. And we're having the darndest time. We're finding people because their information is no longer on track.
Do we want to?
Brokers are, but the supervisors are.
I don't know.
Fair point on
Huge.
being,
Well, and you could put it in the same line
There
as
it
their
is.
name. I mean, there's plenty of room there. It's, I mean, because
I
we're
would
not
either-
doing columns.
I would
we're going
either
across the
Ron,
page.
do it there or right above the line, just to bring them down to that box. Intermediary
However you like it.
No, you gotta go in the box.
in the box?
Yes.
Okay.
You want me to put no intermediary here?
No.
No.
so the last
Okay,
thing.
do you,
we
is there
look at,
room
I
to
think,
put the
is
phone number of the licensed supervisor?
I think so now, doing it this way, because you get a lot more room.
Okay,
doing it this way.
Would you add that? And then I'll make my fourth damn, I mean.
So you wanna- You want to put,
No, no, but this.
Amy has something else.
you want to put the phone number of.
Chair.
It's just a,
If you want to.
technical, I'm not technical.
Hold on, Mary,
Whenever,
Mary,
Ron,
Mary.
Mary.
after you add the phone number, I think it would be better on the first line of each, for the seller and the buyer, broker, to say represents instead of representing.
Okay,
We have represents in the
Yeah.
current form, so I think that would be consistent.
I like that.
All right.
See, everybody stops and listens.
That's not licensed association, is it? It's licensed supervisor.
But
I got this too small. I can't even see.
Would it be okay for us to say that as you all are trying to format this in the new form, if you see like where there was a license number on here that we forgot or a phone kid that you all can.
Yes, we'll look.
Yeah, so I think we don't have to be too worried about it being exactly.
And
He
Ron,
makes everything right.
you want to go
Yeah.
up a few lines and change representing to represents on that also, still in that box for the buyer, right there. And then, of course, go down to intermediary and change the represents to representing when you have for a minute. Look at our perfectionist with his lines.
All the fun stuff, right?
We're gonna do the license number there. You should do it
You-
off to the side for
you
the
need to
associate.
say instead of have a whole line.
Okay, I was just trying to give more room for
Amber's getting big.
the name.
Right, okay, and it represents right up there.
Okay.
Right.
Oh, and I need to put this in there. Abby, you can put the license number wherever you want.
Yeah.
I'm not gonna make the change.
Right. Stick it on there. Now you can get rid of that bottom line.
I think it's a huge improvement.
Well, it's clear.
All right,
It's clear.
I think we're just about ready.
fourth amended motion
Thank you.
with the corrections and changes and improvements that have been made as depicted on the screen. I move that we accept this language as presented, as formatted, and move it forward to Trek.
Second.
All in favor, say aye.
Aye.
Say yay. It carries.
Yay. Ron, if you're being exact, you
Print
want to
names
say.
only, do not
yeah.
sign.
Yeah.
You want that?
Leave it as it is.
At the title company.
That wasn't really part of our change either, so.
That was the title company's one of them.
Yay. I'm gonna write this down, you know, when I told you at your first meeting, you got something done. This is
I think
my
we should
last
call
meeting.
this.
You got something done.
Last meeting got something done.
One song.
SJ, yeah, the Swan.
The Swan song. Pretty good, but, and
What
actually,
was the Jacobus?
Oh, there were a bunch of them,
there's so many.
but we've taken them all out.
Okay. The first, we had something at the first meeting after he was gone that he was very against. I don't
Oh,
think
it was
wasn't.
the, I don't remember. I think we took out the survey to piece in one meeting and put it back in.
This is all said and done. Okay, so
That was all of our deferred.
I think that's all the deferred. I think we went through the new comments.
I think so. I think so.
I think you did, yeah.
If you
Yeah.
didn't, Amber will.
Phone number.
She's back there taking notes.
Yeah. Oh, wait, I don't have the associate's phone number, do I?
She knew where this was going.
She'll do it. She's listening and she's already done it, yeah.
Well, while he's adding that, I can go over the court case that's in here and please pick up if I.
Oh, Latra wanted to do that one. She wants to.
Oh,
Read
you
it.
want it?
Oh, yeah.
There's one court case that we had to review with Mary Masterson as the Secretary of the State for John C. Masterson versus, I'm not even going to try, BC HIH Title of Texas and ARMV5 LLC. It's out of the Court of Appeals in the First District, number 01-23-00127-CB. It's an interesting case that had a seller go under contract with a buyer, execute contract with a buyer that had indoor signs as part of the buyer's name. The buyer ended up assigning the contract to buyer number 2 and the seller never signed the assignment, right? So you had buyer one, buyer two sign the assignment, but not the seller. The original contract didn't have an option fee, didn't have any option period. The assignment called for that, called for an option in additional earnest money. Ultimately, the second buyer attempted to both cancel the assignment. The buyer tried to cancel the assignment and terminate the contract. And the seller said no, and actually tried to negotiate for the earnest money at the time. And they couldn't reach an agreement. And so a lawsuit ensued. The title company made a settlement agreement with the seller saying we'll release the earnest money under XYZ terms. And both the buyers were involved in the lawsuit as well. The interesting thing here is the seller, or one of the interesting things, the seller tried to claim to be a third-party beneficiary of the assignment, but at the same time was effectively arguing there wasn't an option period and there wasn't the option money. That was their own separate contract between them, and so they don't gain the option. But at the same time, I'm a third-party beneficiary, and I should benefit from it in different ways. And so there's a lot behind the case as well. And ultimately, what happened is the court granted a motion on some of the issues, and then the seller dropped the rest. And ultimately came back on the title company, right? On this one, that the title company, whether that settlement agreement was enforceable and whether they had to give up pay the earnest money, and how it turned out. See, the court could not conclude that the new buyer's assignment and the seller lacked privity, right? That's one thing. You have to privity contract to be enforced or be third-party beneficiary. And the court on the record couldn't make the decision on whether there was enough privity there, whether they were a third-party beneficiary of it. And then that with the title company, how this one ended up with title, I think they ultimately had to pay, I think they enforced this one, if I recall. I remember that side of it because I'm no longer in title, so don't worry about that. But it's a very interesting read to understand the complexity of the contracts that you enter. And that details matter, facts matter, words matter, again, like we always say. And in this case, assignments are very common out there. As license holders and as consumers, it's be cautious in what you draft, be cautious in what you sign, because it will be interpreted later and it may be very clear to you, but there's lots of minutia and legal arguments in between the lines. And in this case, you can see went all the way through the courts and was kicked back after the trial court to the appellate court, back to the trial court because they still needed more facts. And imagine how much money is being spent on attorney's fees here. And I think that was one of the issues with the title companies, right, how much they could get with the attorney's fees at the end under the settlement.
Can I add 2 comments? Just boiling it down to 2 big major takeaways. The court explained what an offer and an acceptance versus a counteroffer. And it reminded us all, and settlement agreements are contracts just like the real estate contracts. So if there's an offer, it has to be accepted on the exact same terms, and you cannot add in one new term at all, which, like in this case, was sign this release. We're not going to pay you till you drop the lawsuit. Some other BS that the person who acted like they were accepting the settlement agreement added. All right, but that was a true counteroffer, and the person who was suing said, no, I said, if you didn't accept this by such and such time, I'm going to sue you. And now I've sued you. So I've incurred more fees and I'm not going to, do all your other things. So, bottom line on that, the exact terms are required to accept an offer. And a counteroffer is a whole different animal. And then the other thing, as a lawyer here, I'll remind all of us, and that it came up multiple times in the case, is that the attorney's fees, went way past the amount in controversy very quickly. So on the first turn, of, the set of arguments about, hey, you didn't accept my offer. Here we are. The attorney's fees went from $250, is what the plaintiff said she'd settle for, to $41,000. And I can assure you they're double or triple that now. So, and that's a real thing, you know, and you know, the contracts allow for the prevailing party to get attorney's fees. So
I
Those
was
are two
shocked
big
that an
things.
earnest money deposit of $1,000 that.
Yeah.
Right,
Yeah. I was like,
right.
And that's
Ms.
where-
Masterson is
This is,
stubborn.
it's the principle of.
It is.
Yeah,
what
there you go.
and there's
She's
practical
gonna
and
win.
legal on every
She's
side.
gonna win.
You might have a legal right, but practically be difficult to enforce and
Right.
with the amount of controversy, relatively speaking. So it's
The principle of.
principle it's
being
expensive to fight on, but
Yeah.
you can, and obviously they did, and they're continuing to fight on this.
Yeah,
one.
they're continuing.
It also points out emotion and how important the emotional aspect of how people act and react is, because it was her father's estate. And I think that's why she dug her heels in for the
I
principal.
don't know.
She got mad at that title company too.
Yeah.
There are only two people smiling at the end.
Statement. Let's move on.
That's assuming they were paid.
Yeah, yeah.
Yeah.
But I think that's what we have on the agenda. I want to circle back to, we did, we can go expand. So the seller's disclosure, I'm sorry, we can bring it back. We made the tweak in 7H. And then I don't think there's anything in particular. We can tee it up on the pedestal on anything else in the seller's disclosure that we would like to go.
That was it. That was, we hit it.
That was the
Yeah.
one change, but we can, because it's on the agenda, is there anything to add to?
Just two little things. The question of what a range is, it's an old word. And other places we've seen /stove as clarity. Can we have any impact, or because this is a property code?
So it kind of circles
There you go.
back to that. I'm still of that camp of the changes we're making here from
Yeah.
Sunset. We're sending it up, not saying this is something we as the committee would push out ourselves, but we were requested by Sunset to provide it and leaving it in the commission's hands, whether they decide to add it or not. And that has been an issue in stove versus range, that somebody has submitted materials that maybe about 2 years ago that it went into that in detail, had that exact thing where it went into the differences between them. But I would default back to,
Then you
I
just
like
submit
sticking
that
to
to
the
the
statute
Yeah.
and I don't necessarily agree with, us changing the other things. So not changing that one.
Formatting wise, there's just a line missing in front of fireplace and chimney.
And I think we can make that one for sure.
Yeah,
Bless
we
you.
can.
That'd be
Abby, are
definitely-
you, and Ron, can we write that down? There's a line missing by
Right.
fireplace. Chimney.
And these forms are a work of art if you get behind them. I still think it's a publisher that's used. So it's not as easy as Word just to throw these things, move them around. It's a lot of work on the back end to format. So thank you all for.
We need to have that global, we need
We
to have a
don't know how she
global
does
motion to push all the things through that we said we were going to push through, including that first item, the first changes of our, forgot what they were, where we talked about.
I think we need
would
the
have
forms
a
as
global.
drafted and revised here. We can-
So I
we
would,
wanna make that
if that's
motion.
the time, I would make a motion that all of the items that we have discussed and approved and said we're going to push forward, that now that we have them all together, we approve them and push them forward to the commission for approval at their next
Second.
meeting.
All in favor, say aye.
Aye.
Aye. I guess say nay.
Hi.
Yes.
So back to the changed from terminology, other broker and listing broker, I think. So I've tried to go through quickly. I've identified one other form, that's the lead-based paint addendum, that uses that terminology.
yeah.
Do you want just to notate in your minutes so that we can look for
Do that.
other consistencies,
Okay.
other references there?
But isn't the lead-based paint addendum a statutory?
I was gonna say, I
We
think
can't
that's
change.
I don't know what about the signature line or the
No.
term.
Oh,
Signature line.
okay,
It's just-
okay.
It's just other.
Yeah.
There is for this particular form.
It's down here at the bottom.
Yeah.
Actually, I think even the federal statute allows some flexibility in that
Okay.
form anyway. So I think if we
Yeah,
just
that's a
instruct
great
you to
idea.
change those, okay.
It as available?
Yes.
Thank you. Thanks for that catch over there.
And as Ron's done that, I've circled back to the beginning here and just want to thank SJ, Lee, Amy, and Ron for your 12 years respectively, and Ron's 18 years of service. This is,
Thank you.
we've had a lot of fun over these times. It's been long. We've had arguments. We have fights. I still think this is a magical committee that comes together with brokers and lawyers in a way like none other in the state. And so I pray it's in large part to you all and what you do every meeting and your passion and drive behind it. And I would like to give you an opportunity if you want to say any last words, if you will, before you go, to have the opportunity to at least say that before we adjourn for today.
Before they do, I want to thank you for everything, especially last night, and for the presentations, and for my goat. And your dog. Michelle. What did you get? You got your little halo.
Mine is
The halo. You're the angel of
Mine
it.
was better.
Oh, yes.
But I do like the dog.
Thank you very much on behalf of everybody.
Yes.
Absolutely. That's the least I can do. So. And I was just reminded we do have one more item of business, approving minutes.
Oh, yes.
Yeah.
Or did you want to allow the?
Yeah, if you want to. I didn't know if they were quiet, but if you want to go
We skipped over
Thank you,
the
next meeting, future agenda
future
item.
agenda
Yeah.
and then the next meeting. So
Thank
don't
you for
affect.
keeping me yeah, so I have the one I have is a comment I can resubmit, and is about the hydrostatic testing addendum. I'm not sure there's any action that we'll take on it, but it was just in the Houston area, this agent and others have experienced people being scared to use the form because of the language that's in there. And so I had discussion over the language of the hydrostatic testing addendum, which I know has come up occasionally over time. And the concern there, one, we do want it to be a little scary, but two, is there a way that it can be said in a way that satisfies the legal concerns that we need, and therefore, in that same time, have softer language that it can be used more often to better protect the parties. So in a future meeting, bring that up.
And do you want to, that's your future meetings?
We have anybody else on future agenda items first?
We just have the announcement. Oh, your next meeting.
Yep. So then the next meeting we have October 10th, 2025. Oh, and by the way, I didn't see anything in the special legislative session that would impact what we do. There's a couple real estate items on there, but I don't think anything will impact our committee. So the next one we have is October 10th, 2025, and January 9th, 2026. It's scary. We're already talking about January of next year. Any issues with those dates?
You said 9?
January, October 10th and January 9th. And of course, we'll probably have some excitement between now and then with the Senate Bill 1968, which will be in effect a very short period of time for our January meeting. So we may discuss that meeting date again when we come back in October.
Get some comments back.
Nobody take that off. I'll get these minutes up here for you.
It's at the beginning.
All right. If you are not here, let me know. In fact, I need to take these yellows off.
You were hoping they'd come in?
No, I was.
Yeah, just copying from the last time.
Yeah, I just copied it from last time.
For the legal holiday, do we need to be more specific in what we are requesting there?
I just did a general reference because it's just changing that, just reference and not really changing the language. Unless you want me to be more specific, I can do that.
Do you want to include, are you talking about including our request to track that they publish the list somewhere on their website? Is that what you mean, John?
No, I was just thinking if or all the only thing we're changing is 662.021 to now section 66, just like that. I didn't know if we wanted to quote the exact language, if we were making any other change than that.
And do
I'm
we
fine
need
with it.
to-
I was just questioning.
And do we need to put, is it at the bottom somewhere that it says we approved all these things and are sending them forward?
That will be in the minutes, yeah, at the end with the motion.
Anyone wants an Altoid? And there is the broker lawyer gum that I will.
So I guess where my concern here, by not having the exact language we need is, right now it says legal holiday, quote unquote, means a legal holiday defined by section blank, right? And so I'm not sure that defined by included or listed, or it may just be fine. I just hadn't thought that part.
I think defined by is the right
Defined
language.
by would be the right one.
Yeah,
I'm gonna go look at it again.
Sorry to bring this back up. I just want to make sure we're clear.
Because we're defining it differently than the way it's technically defined.
Right.
Well, it says dates of holidays. A legal holiday includes only the following, and then it has the two sections. And then when we get to the two sections, it says dates and descriptions of holidays. A national holiday includes only the following. A state holiday includes only the following. I think that's a definition. And that is what we're trying to do, is define it.
Yeah, I'm not
Is
stuck.
that
What?
2.021, is that a typo? Should it be 001? Or is it 021? The first reference.
Yeah.
It was.
Yeah, it had it's a dual reference. You
Okay,
had to go to 021 first, and then 021 pointed you to the 003.
Correct.
Got
So
it.
it was a confusing roadmap. You would
Written by
think. Maybe
legislators.
legislatures, that's what she
Written by
says.
Oh, that makes, which
That
unfortunately,
That's-
unfortunately are fewer and fewer attorneys, and that's part of the problem.
I'm okay with leaving it defined by. I just wanted to, I hadn't thought about that before. I mean, identified in or defined by.
It's a legal holiday. Let's see, instead of saying define, you might want to say legal holiday identified.
So,
Well, if you're gonna change the word, it would be described, but I don't think we're helping. I think defined is the common everyday man's
Can
word.
you say in instead of by? Would that help?
Defined by? Define
Right.
in?
and I like,
Because
Well-
it's defined by 662.021, because that's where the definition is, but we're defining it by what we've selected. So maybe it's defined
Defined
in
in, I like that.
660.003A and just been the same.
B6.
I don't know if that helps or not, leaving defined, but defined.
The statute says includes.
I don't know.
Yeah.
yeah, at the end, if
I
we,
can't imagine.
Well, it says include in one, and then it says defined. I mean, described, dates and description.
You could just say legal holiday means the legal holidays described in described in those two sections.
You could. Say that again?
Legal holiday means
Means
the
dates.
holidays.
The holidays described. Yeah.
In these sections. In the sections you've got up
Well, we have to make an amended motion again. Beautiful.
Just.
I don't think so, right? 'Cause we don't have.
Friendly amendment.
Well, we're gonna change it in the language, right?
Right. but I'm
Described,
just saying
defined
we're
by
looking
section
at
62021 and substitute means the holidays.
But aren't we
Oh, wait,
changing
we have
the
to take out.
language here?
It means a legal holiday.
We're gonna change it in the. So you're saying we're going back in time and correcting it in the time. Yeah, I like that.
Yeah.
Time
If
travel.
it means to leave a holiday described in section. Okay,
Yeah.
that's fine.
Way to go, E.F. Hutton.
All right.
I think so.
Okay.
Are they the elk
I'm
on
gonna
the
be
rock?
in.
Oh,
We
yeah.
have a parentheses, extra parentheses, and yeah, right there in the line to the right.
Okay.
Slow death, sorry.
Yeah.
It changed its name. It's still there, but it changed its name to
Okay.
D Boral Capital, effective November 8th, 2024. Wow. That's another one of those people are gonna have to know what it means.
Well, now we kind of changed that up with the, I guess that still works, right?
The letter D.
Yep.
I mean, based on, because we've redone the whole page.
Intermediary. I think it's still, we said sellers.
So this, yeah, this D. Do we change how we reported this?
Do we reference the
It's
sheet that
down
you
below.
drafted and just attach
Yeah, I can
them?
move it up here. I can just move it up here like this. And then just put it there. Strike that before I do it. Make sure y'all are okay with that. I'm gonna put this on one page so you can read it together. Fix that.
I'm gonna probably need to have to start at the top again.
We moved everything to this page. That was at the top of that issue.
You need me to go back up?
I would like to see it from the top.
Okay, so this, I just moved it down so that we'd have it on one page. So this
Sure.
deals with the option fee.
Hold on, no, I'm like up in A.
Oh, okay, you're back
Yeah,
up there.
I want
Okay.
to see everything. Sorry. My final act. So on C, let me see D. On that page, we also wanted to uncapitalize earnest money. So go back to C.
It's in there.
And is it?
Mm-hmm. The last. That's the only place it is capitalized. Is in
Yes,
the-
but wasn't there a third term? Go back and look.
There's this option fee and earnest money.
Thought there was a third term.
Contract.
Contract.
The word contract on the.
Well, I thought those were
page.
correct. I thought we were correct.
No, contract's not defined.
There's one spot that,
Oh, there is?
that it was, I think
Thank you,
Diane brought that
Lee.
up, or that.
Okay, so we can just say and.
Was it when we were talking about first contract? Or was it this contract? I remember the conversation, but I don't remember specifically right now.
I think it was just
It was-
receipt of the contract is acknowledged.
Right.
And it's capitalized there and it's not.
Right. Correct.
That's right.
It's in the third, yes. Thank you.
Catch.
You can roll if everybody else wants to roll. What happened?
No, I was taking that out because it got replaced by
Okay.
this. I just didn't want to delete it just yet.
Yep. What's 6?
I need to correct.
D though, because you just said that the staff was told to make the change, but it doesn't.
That's on on any other forms, if it's out there. And it's out there on the,
But should we say in here that it's being changed to buyer broker and seller broker? I know
no,
it's on the attached.
no, what staff is correcting is only the listing broker and other broker because one of those terms is used on the lead-based paint addendum.
I think about the other agenda item for the boxes, right? That's down below. Or is that?
Okay.
No, I merged that up into,
I don't think so. I think it. was
so
already
I merged all that up into this. So do you want
It's
to,
attached
in
to the
any other
minutes.
form, use the term buyer broker and seller broker? Seller's
Oh,
broker?
I see the attached.
It's
to
in the
minutes.
attached.
Yep.
Yeah, so we haven't seen it yet.
So we could say.
Again. You don't need to change it.
Yeah, I think it would
I
be
don't
fine
think you
there
can
with the
change it.
attached.
Just leave it for now.
Okay, but we're not referring to them as buyer broker or seller broker. We're just saying representing the seller, represents the seller, represents the
Right.
buyer.
I think there were 2 conversations going on about what the staff was gonna do. And
Okay,
what
well,
we
let me
were
go to that form and just so you see it's here. So here we go. So the broker information form.
Right. Yep. Yep.
There's also paragraph 17, where it says.
So, in different parts of the form where we currently refer to listing broker, which are not much, do you want to use seller broker for that term? Seller's broker and buyer's broker, just use that?
I think we could even just say brokers. Because it's only an attorney's fees. A buyer, comma, seller, comma, any broker, comma, or escrow agent who prevails in any legal proceeding.
And then you have the lead-based paint form.
Right. Which staff is comfortable changing. We have to go look at it.
No, the question that I think Melissa was posing is, do you want to use the term seller's broker and
No,
buyer's broker there?
in the lead-based paint form?
Mhm.
Other
Or on the attorney's fees, or do we just want to say broker?
I don't know, but if we say brokers, because right now it's we haven't defined those things. They're a capital. Does then that lead to the argument that mortgage broker or other broker, and just having it? Do we need a little more specificity? Maybe it's overly voyeuristic, but if you say
in
any
this?
for attorney's fees, yeah.
It's 17.
Oh,
Well, how about we just do this? Okay, let's leave 17 as it is, but uncapitalize listing broker and other broker because they are not defined terms. Okay, but they're obvious what they are.
Or buyers. We were changing other to buyer. Broker.
Take out
I don't know that you even need to change it, but
Yeah, I think that one to be consistent to remove other broker. It's an easy change. Make it clear.
All
Well,
right.
that's where we started with the whole discussion about that last page,
Yeah,
was
that's-
getting rid of other broker altogether.
Right.
Okay.
And listing.
Uh-huh.
Seller.
Yeah, so to say buyer.
If we want to address paragraph 17, we can do that specifically, or we can just say to staff, if you see the term other broker or listing broker, use the term buyer broker and seller broker.
Yeah,
I think that's the right way to do it.
Okay.
That's more appropriate.
so instead of period, go back.
Let's see what it
You
types.
can finish that prior sentence. You're just duplicating now. Okay.
Well, oh, I see what you're saying.
Finish the sentence and say to, instead of other. You follow me?
Yeah.
Respectively. Yeah, there you go. Right, comma respectively. I'd put respectively.
Okay.
There you go. And then get rid of the new. There you go. Beautiful, beautiful.
Are we using the apostrophe S, buyers, sellers elsewhere?
Well, we took it completely off of the new, broker information page.
We did use like a seller's agent in the old language, or buyer's agent with an apostrophe S is a comparable thing.
Or, I mean, you could say, or agents here.
No, because because agents have to be sued through their broker. Leave it. Now, does that have to be capitalized? Is this if it's not a defined term, we need to uncapitalize
So
it?
I was just thinking about
The
that,
the
SJ,
broker,
and I
just the B,
think
just the
that-
broker part. Buyer is still gonna be capitalized. Sorry.
Okay, well, I was just gonna say. I see what you're saying. I was just gonna say it's descriptive with the buyer and seller. And broker is, yeah.
Yeah, seller and buyer are defined, and then the broker's not defined.
Right.
I think staff has it because we might use a capital B in broker, like under a signature line. or
Exactly.
something.
That's
Because it's the first word.
I think they got it. Yeah, that's good.
All right. You need a comma after
We have to
2025.
wait until 3:50.
Well,
Hey, Ron,
we're well on our
yeah,
way. I'm not
yeah.
concerned about it.
Hotel California. Could you go back to that?
My
broker
battery's dead.
Information form. And go all the way down to the bottom. I think there was one.
Oh, it's not.
place
It's
you
at
missed.
3:15.
The last associate, the associate license number, you have to substitute that line associate.
Phone number, thank you. You're so close, but yet so far.
That's why I was trying to say to let Amber do it, but
So one space or two after a period? Let's get into that discussion. Always two.
Depends on how old you are.
All right. I do feel like there's some kind of conspiracy here. Don't you, Amy?
Make your last meeting go till
It's some kind of conspiracy to keep it going.
I got your hopes.
Yeah.
Hey, I tried.
you did, but it's okay.
Please change that 350 to another time.
Any final words? I know Ron gave it to you. Any final words before we go? Okay.
It's been fun, y'all. It's been fun. We'll miss seeing you all. And I wanted, actually, Ron sort of stole my words because you said, do you want us to say anything? I was gonna say, particularly after you mentioned spending 3 days on a
know.
potential
Yeah.
buyer's representation, the amount of time that you've devoted, and I know you're not leaving, but I'm just saying, I'm gonna tell you thank you for all of the effort and stuff that you've put into your time as chair, because it's super appreciated. It's been very thorough.
Thank you.
Appreciate it. But we'll miss all of you, but if you're ever in Lufkin, give me a call. I'm easy to find. It's a small town.
Thank you.
Well, I have thoughts too. I do want to share, and certainly I ditto to all the praise for John, because it's not often we see somebody, put that much time into these things, and it is appreciated by all of us. But since I'm leaving, and promise you I will not be back, I do want to leave you with a reminder, and that I think everyone who sits at this table knows that what you do is important. I don't think you have that full concept of how you influence the industry, not only in our state, but across the nation. When you put things into forms, people who don't understand the law translate them into their own language with their own perceptions from their own perspective in their own belief system. And that's how change is effectuated in our real estate marketplace. I think you have to keep that top of mind, because for most users of the form, whatever's in the form, they believe is the only option. So I think you have to keep that top of mind as you go forward, especially with the industry changes that are coming forth and will continue. I mean, I think the next 10 years, you're going to see a lot of change, and you will see it closer than I will. And the last thing I'll say is if you take away my 5 p.m. deadline on auction, I will come back.
All the comments.
You will be, you will remember my name if you.
How to get her show back up now.
You mess with that 5 p.m.
Oh, that's how
I will hunt you down.
Well,
Face you see.
I want to add, I want to add just a few of my own comments and, and piling on to the thanks to John. But I also want to thank Ron, who has the hardest damn job at this table. And you do it, you're typing, you're thinking, you're explaining, and you've been incredible. And thank you so much. And you've done that the whole 12 years I've been here. I know you've done it the whole 18 years you've served on the committee. And I know you will continue to assist, real estate going forward. I don't know that I echo, I'm not as strongly, about the 5 days as Lee, but I echo my colleagues. Yeah,
I don't know how many days it is. Don't make
I
me
think that's
say it.
good. I won't hunt you, but I echo the comments of my colleagues that it has been fun. This has been a labor of love, heavy on the labor sometimes, but please continue to take your job seriously. Don't phone it in. Really respect how important it is, what you're doing, and please train up whoever replaces us properly. I want to also thank all the people that are here. Thanks for coming, and thanks and online. Thanks for caring. Thanks for listening and providing us with your comments, either sending them in to the committee, or giving us comments here. That's important. But I don't think I can sing, but thanks for the memories.
In the Oxford comma will live on.
Oxford.
We're going to get that.
In your
Well,
honor.
In your honor.
Thank you.
I'll keep that fight up.
She has her 5 p.m. and
That's-
SJ.
Oh, yeah. And I will.
There you go.
That's it. Well, thank you again. I really appreciate the service, and we'll make sure that you're involved one way or the other, whether you like it or not. So with that, we'll call the meeting to a conclusion at 1:31.